Elizabeth, you are the host now.
Madam Hearing Examiner, if you can hear me, I can't hear you.
Try again. Can you hear me now?
Yes, ma'am. Thank you.
Awesome. I'm having some technical difficulties this morning and no assistance. Who is SPS Attorney 1?
Good morning. That is me, Dana Hardy.
All right, you get to be number 1.
I'm
Miss
number
Hardy.
1 for the moment.
What about 2?
Good morning, Madam Hearing Examiner. This is Erica Kane here also
Hi,
on
Ms.
behalf of
Kane.
the. Hello, good morning. We may have 2 other colleagues joining us as the hearing progresses, so we are currently unnamed attorneys, but we'll make sure Mr. Lee has our names.
And I did see a notice of filing, Ms. Hardy, Ms. Kane. You thought maybe you better add Mr. Moss?
That's correct, Madam Examiner. Mr. Moss is here and he may take certain witnesses depending on which witnesses are called.
Okay, and this person is you, is SPS Jocelyn Barrett Capon?
I believe she represents Walmart.
Is Moss
Oh,
MOSS?
yes, it is. It is. Good morning, Mr. Lee.
Good morning, Judge. How are you?
I'm well, thank you. Good to see you.
Good to see you too, Judge. I'm
And
ready.
Miss.
I'm ready for the show.
Oh, awesome. Mr. Brigacco, you have co-counsel in Miss Ellis?
Yes, I do.
Okay,
And Mr. Ryan Friedman. But
okay.
as it pleases you, you know, they will assist through the proceeding. But if you'd like, we can also have them watch from YouTube if that makes you feel better about bandwidth, et cetera.
Well, you know, as I advised in the pre-hearing last week, everyone that's on the Zoom is expected to be present, audio and video, during the whole proceeding. So if you're co-counsel, you know, as long as your co-counsel know that, you know, unless people are excused, I'm willing to have them. They just have to comport with no black screen. I don't want to see any black screens.
I understand that they heard that announcement and that they understand it themselves. So thank you very much for that.
Very well.
Hold on.
Madam Examiner, Mr. Moss and Mr. Stewart, Jeffrey Stewart, also is present, but they will not be on the Zoom unless they are going to handle a witness. And in that case, we will
Okay.
swap places, if that's acceptable.
Okay, no, that's absolutely fine. Has anybody got anything procedural before we begin our hearing?
Can you hear me? Is that better?
Madam Hearing Examiner?
Hi, Mr. Getka. Good
Yeah.
morning.
Good
I
morning.
can hear you. Yes, sir.
If we are in a situation where, we've requested to not be present at some point during the hearing, do we just come back to the Zoom and hope that you see us in the waiting room? Or how do you want to handle returning? Not that I've even planned to not be here, but there will be some switch off.
Well, I mean, I get a pop-up on the side of the screen that says when people want to be admitted. So I think we could try that. If that doesn't work, obviously you can email me
Okay.
and let me know.
All right. Thank you.
Okay, thank you.
Ms. Hurst,
Mr. Marks, good morning.
good morning. At the
Yeah.
pre-hearing, we left unresolved the logistics for Sierra Club to introduce its confidential exhibit.
Yes.
That's something we should cover before we go on the record.
That was just the one procedural thing that I need to discuss. And then I've gone back and forth, quite frankly, on having a confidential exhibit in the record. And I know that when we discussed it on Friday, or I discussed it with myself on Friday when we had the pre-hearing last week, that I said I wanted it in the record. And because you were willing to not admit it. But in going back and looking at 20-00238, I think you went a step further and you actually offered to withdraw it. Are you willing to do that? And you need to think about it.
No, if there's no objection from any of the parties, and that would make it cleaner, Sierra Club we could go on when we go on the record, we can make a motion to withdraw it.
Okay. Okay, parties can think about that. And that's the only procedural issue that I had, other than asking parties. I know I have your pre-hearing memos, which you indicated witness constraints and availability. Because we have so many witnesses, and I've not I like juggling chainsaws, but I would please appreciate if you would advise me if it looks like your witness is gonna be that we're gonna have difficulty. So for example, this week, I know that Mr. or Dr. Woolrich is only available Friday. And Ms. Crane is only available Wednesday and Thursday. And we have an open meeting that I don't know how long it's going to take. So I just asked the parties to just please give me a gentle reminder if it appears that we're going to run into any difficulty. And that's really the only procedural matter that I wanted to address. Okay. If we don't have anything else procedural, you probably got the alert. We are already live streaming. And so I'm gonna admit whoops.
Madam Hearing Examiner?
I just made a mistake. Mr. Long, you're gonna have to listen on YouTube. I just admitted you by error.
Oh, okay. I'm a witness in the case, but I should just join the Zoom when I'm up. Is that correct?
Yes, sir.
Okay,
Uh-huh.
I apologize. I'll move over.
Not at all, sir. Thank you so much. If you would just, exit your
Will do.
Zoom.
Yep.
Thank you.
Madam Hearing Examiner?
Yes, sir.
It was just simply because you just made a statement of Miss Crane being available only Wednesday, Thursday. I believe she's also available today, but just up until I need to triple check it. I think it was 3 p.m.
Okay.
Just so you know,
Right,
you have
and
that option too.
right, and I'm going to try to go as closely as I can. I'm going to try to follow the witness order, but again, when there are constrained witnesses, they will be called out of order. But thank you.
Madam Examiner,
Yes, Ms. Hardy.
I had one procedural matter. And just so that we can make sure we have witnesses available when we need them for you to hear from them. Will we have information on, or can we get information on which witnesses we won't need to present? Or has that not been determined?
It is a fluid situation, Ms. Hardy.
Okay,
And I am trying, I have a potential addition regarding that matter, but it's got to be verified. What I'm trying to avoid is that we because I don't have questions for a witness, doesn't necessarily mean that the commissioners don't have questions for that witness. So what I'm trying to avoid, although, as I indicated at the pre-hearing last week, I'm trying to avoid waiving them and then saying you have to bring them. Okay.
okay, I understand. Thank you.
That's one of the chainsaws that I'm juggling. Okay. All right. Thank you so much. And with that, good morning. My name is Elizabeth Hurst. I am the designating hearing examiner in case number 2200286 UT. This is in the matter of Southwestern Public Service Company's application for revision of its retail rates under advice notice number 312. And they are asking for not only revision of its rates, but authority to abandon Plant X Unit 1, Plant X Unit 2, and Cunningham Unit 1 generating stations, and to amend the abandonment date of the Tolk generating station, and for any other associated relief. Along with me today is our court reporter, Mr. Lee. Should anyone need anything to do with the transcript, they will need to contact Mr. Lee directly. Welcome. This is the beginning of the public hearing, and also along with me today is the chairman of the Public Regulation Commission, Chairman O'Connell. Good morning, sir.
Morning, hearing examiner.
And Commissioner Ellison is also with us here this morning. Good morning, Commissioner.
Good morning.
Today is the date, time, and place for the hearing. As was indicated in the procedural order, which was published and mailed to 91,305 SPS customers as indicated by the affidavits of publication and mailing on January 6th is when the notices were mailed, and the web posting occurred on January 10th. Publication occurred in the Hobbs News Sun, the Carlsbad Current Argus, the Quay County Sun, the Eastern New Mexico News, and the Roswell Daily Record. I would like the record to indicate that there was no one who signed up this morning to give public comment in this matter. If I could go ahead and get appearances on the record, and I will just call the parties in order of the proposed order of presentation. So, Ms. Hardy, we can begin with you. If you'd enter your appearance, please.
Thank you, Madam Examiner. Dana Hardy on behalf of SPS, and also appearing for SPS are Ms. Erica Kane, Mr. Jeffrey Stewart, and Mr. Ron Moss.
Good morning. Thank you.
Good morning.
And Mr. McMillan, if I could get your appearance, please.
Good morning, Your Honor. Michael McMillan for Occidental Permian Limited.
Good morning. Mr. Getko,
Good morning, Madam Hearing Examiner. This is Kevin Gedko for the New Mexico Office of the Attorney General.
thank you. Ms. Drake,
Good morning, Joan Drake for Louisiana Energy Services, or LES. My partner Susan Miller is watching on YouTube, and she will stay on YouTube unless she is presenting a witness.
thank you. Good morning. Major Buchanan,
Good morning, Madam Hearing Examiner. Major Holly Buchanan on behalf of the federal executive agencies.
thank you. Good morning. And Mr. Stoffel or Mr. Rushoff?
You've got Mr. Stoffel here. Good morning.
There, Mr. Stoffel, there you are.
The law firm of Holland and Hart, appearing on behalf of the New Mexico Large Customer Group. I'll also enter the appearance from my colleague, Austin Jensen.
Thank you. Mr. Moffett,
Good morning, Madam Hearing Examiner. Mike Moffett.
good
on
morning.
behalf of COG Operating LLC.
Good morning. Mr. Marks,
Good morning, Ms. Hurst and council. Jason Marks appearing for Sierra Club, and with me is Stephanie Zur, also local counsel for Sierra Club, and Joshua Smith.
thank you. Good morning. Welcome back, Ms. Zur.
Thank you, Your Honor. Good morning to you.
Thank you. And I don't have Mr. Bartell, but I have the representative for Walmart is, there you are.
Good morning, Madam Hearing Examiner. This is Jocelyn Barrett Capon from Montgomery and Andrews on behalf of Walmart Incorporated. I'm also entering an appearance for Mr. Bartell, who will be joining in my place occasionally.
Very well. Good morning.
Good morning.
And Mr. Begacco?
Madam Hearing Examiner, good morning. John Begacco, and I'm accompanied by Joan Ellis and Ryan Friedman on behalf of the New Mexico Public Regulation Commission Utility Division staff.
Excellent. Good morning. And then for CCAE, Ms. Lynch?
Good morning, hearing examiner. My name's Kara Lynch. I'm here representing Coalition for Clean and Affordable Energy. Before moving on, our witness Noah Long is unable to access the YouTube link for some reason.
Okay, might have him go back out of, totally cancel out of Zoom, go back on the commission link and make sure he hits refresh.
Okay.
Okay.
See if okay.
Okay.
I'll let you know if he's unable still.
Okay.
Okay.
All right.
Thank you.
That's, I believe that's usually the advice I get from the IT department. Okay. All right. I apologize if I missed anybody. I did. Ms. Beatles, would you like to enter your appearance, please?
Yes, thank you. Good morning, Ms. Hurst and Council. Sydney Beatles for Western Resource Advocates.
Good morning. Okay, with that,
Madam Hearing Examiner,
Mr. Getko.
I apologize. I should have entered the appearance of Gideon Elliott as well. He will be replacing me at certain points due to other matters.
All right, sir.
Thank you.
Thank you. All right. Well, if we've got all those appearances on the record now, then I think everyone knows where we are, and we are about ready. I have one more procedural matter that I would like to indicate for the record. I've already indicated for the record that we had no one sign up for public comment, which makes me a little sad, but we did have one written public comment that was presented to the commission on the 16th of January of this year. And this public comment was from a person who identified himself as William Marty Tressel. And Mr. Tressel indicated that he was a customer of SPS in Clovis, and I can generally characterize his comment as being opposed to the request's consideration of non-traditional generation methods.
Judge, can you spell Tressel?
Sir?
Can you spell Tressel?
I can. It's Tressell.
Thank you, Judge.
Thank you, sir. All right. We've had a brief discussion that was live streamed already on YouTube. We are going to begin the evidentiary portion of our hearing, and generally, just for the parties who may not have appeared before the commission before, let me indicate to you that the way that these hearings go is that we try to run them from 9 to 5 with a break in the morning, a recess, and a recess in the afternoon. Additionally, we usually take an hour for lunch. As I've already indicated, we have attorneys and a witness and the commission on the Zoom, and all other parties should go to the commission's website and click the link and watch on YouTube. So with that, I would just like to remind or state for the record that as part of the pre-hearing process, parties were required to submit their exhibits in the Dropbox, their final exhibits. And parties need to make sure that if the exhibit that you offer is not in there, that we need to talk about that. Okay. With that, I believe we're ready to begin the evidentiary portion of our hearing. Ms. Hardy, you have a witness.
I do, Madam Examiner, but before we present our first witness, I would like to introduce into evidence a couple of the stipulated exhibits, if that's acceptable.
Very well. Yes, ma'am.
The first one is the contested comprehensive stipulation, which has been marked as signatories Exhibit 1.
Okay, Ms. Harder, what you've identified as signatories Exhibit 1, the contested comprehensive stipulation, is a document including attachments that was submitted, the document of 91 pages, and that was submitted into the Dropbox as signatories Exhibit 1. Have there been any additions, corrections, or deletions to that document?
There have not.
And is the document you're offering the version of signatories Exhibit 1 that was placed in the Dropbox?
Yes, it is.
Is there any objection to what's been identified as signatories Exhibit 1, the contested stipulation as filed with the commission? Hearing no objection, signatories Exhibit 1 is admitted.
Thank you.
Ms. Hardy?
The second exhibit I would like to move into evidence is SPS Exhibit 1, which is the application filed by SPS in this case.
Is it really necessary, Ms. Hardy, for us to submit the actual application, or is SPS, would it be sufficient for SPS that I just take administrative notice that SPS filed an application with the commission in this case?
Madam Examiner, I think that's fine. Although all of our exhibit numbering, is sequential following the application. And it does include our tariffs as well, but they were also, submitted into the record.
Well, if there's no objection, I can admit Exhibit 1. Just trying to make the record a bit more svelte, but any objection to what's been identified as SPS Exhibit 1, the application? Ms. Hardy, the version of the application that was submitted as SPS Exhibit 1 into the Dropbox, That is, in fact, the application that was filed with the commission in case number 2200286.
It is,
It's a document that's of 85 pages.
correct.
Very well. Hearing no objection, SPS Exhibit 1 is admitted. Ms. Hardy?
Thank you. The final preliminary exhibit is SPS Exhibit 2, which is SPS's notice of filing of affidavits of publication and web publication.
And I believe we've already reflected the affidavits into the record. SPS has in fact complied with the order that I issued regarding publication, individual mail service, and posting on the web. That is a document of 48 pages.
Correct.
Any objection to what's been identified as SPS Exhibit 2, the affidavits attesting to notice? Hearing no objection, SPS 2 is admitted. Ms. Hardy?
Thank you, Madam Examiner. Those are all of the preliminary exhibits that we have. So we would call our first witness, Adrian J. Rodriguez, and Ms. Kane is going to present his testimony, and I believe that he is in the waiting room.
I already let him in.
Oh, well then, thank you.
Ms. Hardy, I had indicated last week that there, at that point, that I was willing to waive 3 SPS witnesses. Do you want to go ahead and stipulate the testimony of those witnesses in at this time?
Sure.
Go ahead.
Okay, and I believe that those witnesses, let me just find the exhibit numbers. Okay, one of them was Sudine Kelly, correct?
Yes.
Correct, okay. Ms. Kelly's direct testimony is SPS Exhibit 14. And her rebuttal testimony is Exhibit 15. And I would like to move those into evidence.
All right, let's talk about those. It's not as much fun working on 2 computers as I thought it would be. And for the record, I just want to indicate that the parties were in agreement that, and since there is a stipulation in this case, and that because the only party that has scheduled cross-examination for the witnesses to the parties who signed the stipulation, the parties were in agreement that the testimony under certain conditions could be admitted without the appearance of the witness. The qualifications that I have for stipulated testimony would be not only that it is correct, accurate, complete testimony that's been updated for any corrections, but also that there be a witness verification of this testimony. Ms. Hardy, does Exhibit 14 meet that criteria?
Yes, it does, Madam Examiner.
That is a testimony of 37 pages. Are there any objections to what's been identified as the direct testimony of Sudine Kelly? Hearing no objections, SPS Exhibit 14 is admitted.
Thank you.
And SPS Exhibit 15 is the rebuttal testimony of Sudine Kelly. And a document of 24 pages put into the Dropbox by SPS. Does Exhibit 15 meet all of the qualifications to be admitted as stipulated testimony into the record, Ms.
It
Hardy?
does. It does, Madam Examiner.
Very well. Any objection to what's been identified as SPS Exhibit 15? Hearing none, SPS Exhibit 15 is admitted.
Thank you.
Ms. Hardy?
Thank you, Madam Examiner. The next exhibits would be for Mr. Richard R. Shruby. And those include his direct testimony, which is Exhibit 59, his supplemental testimony, which is Exhibit 60, and his rebuttal testimony, which is Exhibit 61.
Exhibit 59 is Mr. Shruby's direct testimony, a document of 117 pages placed into the Dropbox. Ms. Hardy, does that particular Exhibit 59 meet all of the qualifications to be admitted as stipulated testimony?
Yes, it does.
Any objection to what's been identified as SPS Exhibit 59? Hearing none, Exhibit 59 is admitted. Exhibit 60 is Mr. Shruby's supplemental testimony. And that's a document of 9 pages. My understanding is that SPS submitted supplemental testimony of certain witnesses that supported the corrections to its application. Is that correct, Ms. Hardy?
That's correct, Madam Examiner.
And is this document of 9 pages, does Exhibit 60 meet all of the requirements to be stipulated into the record?
It does.
Any objections to what's been identified as SPS Exhibit 60? Hearing none, SPS Exhibit 60 is admitted. SPS Exhibit 61 is Mr. Shruby's rebuttal testimony, a document submitted to the Dropbox of 15 pages. Does SPS Exhibit 60 meet, Ms. Hardy, all of the requirements to be stipulated into evidence?
It does.
Very well. Any objection to what has been identified as SPS Exhibit 60? Hearing no objection, SPS Exhibit 61 is admitted. Ms. Hardy?
Thank you. The next exhibits, Madam Examiner, are for Michael P. Desalich. And those numbers are Exhibit 62, which is his direct testimony, Exhibit 63, which is his supplemental testimony, and Exhibit 64, which is his rebuttal testimony.
SPS Exhibit 62, Mr. Deselich's direct testimony, a document of 110 pages that was placed in the Dropbox by SPS. Ms. Hardy, does SPS Exhibit 2 meet all of the requirements for stipulating into the record?
Yes, it does.
Very well. Any objections to what's been identified as SPS Exhibit 62? Hearing none, SPS Exhibit 62 is admitted. SPS Exhibit 63 is Mr. Deselich's supplemental testimony, a document placed into the Dropbox of 21 pages. Does SPS Exhibit 63 meet the requirements for stipulating testimony into the record, Ms. Hardy?
Yes, it does.
Any objection to SPS Exhibit 63? Hearing none, SPS Exhibit 63, Mr. Deselich's supplemental testimony will be admitted. SPS Exhibit 64 is Mr. Deselich's rebuttal testimony, a document placed into the Dropbox by SPS. Of 34 pages. Ms. Hardy, does SPS Exhibit 64, Mr. Deselich's rebuttal testimony, meet the requirements to be stipulated into the record?
Yes, it does.
Any objection to what's been identified as SPS Exhibit 64? Hearing no objection, SPS 64 is admitted.
Thank you, Madam Examiner. Those are the exhibits that SPS will request for the stipulated witnesses.
Very well. And subject, I'll just remind parties, we've discussed this at the pre-hearing, but the stipulated testimony is an efficiency measure for the hearing procedure. Should it become necessary because of circumstances during the hearing to call those witnesses, parties are so advised that that could occur. And with that, I believe you already called Mr. Rodriguez. So good morning, Mr. Rodriguez.
Morning, Madam Hearing Examiner Hurst. It is good to see you again.
Good to see you. Just a bit of procedure we had to get through there. I know it's supposed to expedite things, but you know, it took us a little while. So we'll go ahead and begin with you, sir. And Mr. Lee, if you would please swear in Mr. Rodriguez.
Mr. Rodriguez, if you'd please raise your right hand. You solemnly swear the testimony you're about to give the matter now pending should be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you, sir.
Thank you, Mr. Lee. Ms. Hardy, no, you said Ms. Kane is going to represent this witness, correct?
That is correct.
Go ahead, Ms. Kane.
Thank you, Madam Hearing Examiner. For the record, this is Erica Kane on behalf of SPS. Good morning, Mr. Rodriguez.
Good morning.
Could you please state your full name for the record?
Adrian Jose Rodriguez.
And could you please tell us your place of employment and your current position?
I am the president of Southwestern Public Service Company.
Thank you. And do you have in front of you a document marked Exhibit SPS-3?
I have my direct testimony in front of me. Yes.
Thank you. And so just for the record, Exhibit SPS-3, it would be your direct testimony you filed in this matter?
Yes.
And was this document created by you or under your direction?
Yes.
And if you were asked the same questions today that are in your direct testimony, would you have the same answers?
Yes, subject to the revisions in the supplemental testimony.
We'll get to that in a moment. And Madam Hearing Examiner, I'd like to offer for admission Exhibit SPS-3.
Mr. Rodriguez, you've indicated that the testimony is turned correct, subject to your supplemental testimony.
Yes.
Do you have any attachments to your direct testimony?
No.
Are you sure?
Oh, I'm sorry. I apologize, Madam Hearing Examiner. I misinterpreted the question. I have attachments AJR1, AJR2, and AJR3.
And were those attachments prepared by you or at your direction and control?
Yes.
And if you were asked the same questions today as were in your testimony, would your answers be the same?
Yes.
Very well. Any objection to what's been identified as SPS Exhibit 3, Mr. Rodriguez's direct testimony? Hearing no objection, SPS Exhibit 3 is admitted. Ms. Kay?
Thank you, Madam Hearing Examiner. Mr. Rodriguez, do you have Exhibit SPS-4, the supplemental testimony of Adrian Rodriguez in front of you?
Yes, I do.
And was this document created by you or under your direction?
Yes.
And if you were asked the same questions today that are in your supplemental testimony, would you have the same answers?
Yes.
Thank you, Madam Hearing Examiner. I'd like to offer for admission Exhibit SPS-4.
And were there any attachments, Mr. Rodriguez, to SPS Exhibit 4?
No.
Very well. Any objection to what's been identified as SPS Exhibit 4, Mr. Rodriguez direct testimony? Hearing no objections, SPS Exhibit 4 is admitted. Ms. Kay?
Thank you, Madam Hearing Examiner. Mr. Rodriguez, do you have in front of you the exhibit titled Rebuttal Testimony of Adrian Rodriguez, marked Exhibit SPS-5?
Yes.
And was this document created by you or under your direction?
Yes.
And if you were asked the same questions today that are in your rebuttal testimony, would you have the same answers?
Yes.
Thank you. Madam Hearing Examiner, I'd like to offer for admission Exhibit SPS-5.
Any attachments to your rebuttal testimony, Mr. Rodriguez?
No.
Very well. Any objection to what's been identified as SPS Exhibit 5, Mr. Rodriguez rebuttal testimony? Hearing no objection, SPS Exhibit 5 is admitted. Ms. Kay?
Thank you, Madam Hearing Examiner. With that, SPS would tender the witness for examination.
And it's my understanding Ms. Kane, that no party reserved any cross-examination time for Mr. Rodriguez. Is that correct?
That is our understanding, Madam Hearing Examiner.
So I'll put the call out, and just in case one of the parties change their mind, do any of the parties have any cross-examination for Mr. Rodriguez? Hearing none, I have a few questions for you, Mr. Rodriguez. Good morning.
Good morning, Madam Hearing Examiner.
And I guess first, I just would like sort of to know, SPS has, because of the substitution for 2-for-1 with Mr. Luth, SPS has 27 witnesses in this case.
Yes, Madam Hearing Examiner, those are also identified in the testimony of Ms. Trammell.
And I know from your testimony in your attachments, your educational background is in economics and government, correct?
Yes, from my undergraduate years at the University of Texas.
But you also have a master's in public policy and a JD, correct?
Yes,
And you did in fact practice, or you're licensed in Texas and New Mexico, correct?
yes.
Thus, and you have experience in public utility regulation, both at El Paso Electric and at Puget Sound Energy, correct?
Yes, I was directly employed by those two companies and practiced law at a law firm that represented companies in the electric utility industry.
So I guess I'm sort of wondering, as having an educational background in economics, and a lot of the witnesses that we hear from have an economics background, and having a legal background, and we know we sometimes have a lot of witnesses that say that they're not lawyers, but they're allowed to opine on certain regulatory laws and requirements. I'm trying to understand in what context you're giving testimony. Are you, I mean, I think you could be qualified potentially as an expert witness. but yet it seems as if your testimony is very general and almost is like a movie trailer. Or in the olden days, we used to call them scenes of coming attractions. And that your testimony is actually being given in that manner. Can you clarify for me in what manner you believe your testimony is offered?
Yes, Madam Hearing Examiner. As I state in my direct testimony, I am providing an overview of Southwestern Public Service Company in order to provide an introduction of the case and a very high-level summary of the case, for which the specific subject matter expert witnesses will provide specific details. I recognize, especially given my experience in the electric utility industry and as an attorney previously, that the cases can sometimes provide substantial details. And the intention of my testimony was to provide a summary of the case in order to provide a general understanding of SPS's request.
Well, do you have the expectation, Mr. Rodriguez, that the commission should actually make findings on the general information that you provide in your testimony?
I note that my testimony provides a summary of the company as well. And I recognize that there are maybe some requirements to establish that SPS is an electric utility serving customers in New Mexico, subject to the laws of New Mexico and the Public Utility Act. And those aspects of my testimony that provide those details, as well as customer counts, general service requirements, the numbers of substations and the equipment that we have, provides that general information of the company that that is intended to meet the requirements to establish basic foundational background of the company.
Thank you, sir. In looking at your attachment 2 and 3, let's look at attachment 2 first. Tell me what attachment 2 is, sir. Attachment
2 is a map that shows the transmission system interconnecting all of Southwestern Public Service Company's transmission lines in Texas and New Mexico. It also includes some of the transmission system that we have in Oklahoma and Kansas, which is part of our system that is connected to the Southwest Power Pool.
And the lines on that particular map have different colors. Is
Yes.
that correct, sir?
That is correct.
Okay. And can you just, for clarification purposes, can you just tell me what is there a specific color that relates to the power pole?
No, the entire system is related to the power pole primarily at 115 kilovolts and above. 69 kV is for NERC purposes below the transmission voltage that they would consider as something that is under their jurisdiction. In any case, it is the system at different kilovolts that we have and that we rely upon in order to provide service to customers in Texas and New Mexico.
Okay. And then your exhibit 3, can you tell me what that is?
Exhibit 3 provides a map of the general vicinity of generation facilities that are either directly owned by Southwestern Public Service Company or for which we have a power purchase agreement. And it is intended to show the general locations of our generation facilities as they are discussed during the course of the case.
Are all of the facilities that are identified on attachment 3 used to provide service to New Mexico, SPS New Mexico customers?
Yes.
And also on attachment 3, you've identified what the source of the generation is, correct?
We have identified the character of the generation based on the images that are shown: solar, wind, natural gas, coal, and fuel oil.
And is there a particular designation for why part of that exhibit is gray and the other part is like a cream color?
Yes. The cream color is the area that is generally the area served by Southwestern Public Service Company. The gray area would be areas that are outside the service territory of Southwestern Public Service Company. I note, however, that the map is a general map and is not specifically to scale. So as a result, it is to show a general footprint of the company rather than to show specific service territory locations.
Okay, so for example, on this map in the gray, up in the state of Oklahoma, so the right-hand top corner, there is a wind facility that's been identified called Mammoth Plains.
Yes.
So that's a wind facility that's outside of SPS service territory, but yet SPS presumably through is it through a PPA or is it through the SPP that that facility would provide services to New Mexico customers?
That would be through a power purchase agreement, even though the physical location of the facility is outside what is the footprint of Southwestern Public Service Company.
Okay. As part of As part of Commission Exhibit 5, that at that point was a putative Exhibit 5. I put in for the parties advance notice. I put in exhibits that I thought the commission may want to admit. Commission Exhibit 5 is the SPS answers to the bench requests. Those responses were filed. They issued the bench request on June 12th, and the bench requests responses were filed on the 16th. As part of that, I asked that Mr. Lowe, who had included a table of SPS generation resources, I asked that he supplement his table by putting what type of fuel source or type that the plants were. Are you familiar with that response, Mr. Rodriguez?
Mr. Rodriguez, you're on mute.
No, I am generally familiar with the bench request, but I am not familiar with Mr. Lowe's specific response.
Okay, and my question is this, here, let me pull it up. Can you see that, Mr. Rodriguez?
Yes, I see a document.
Okay, and that
labels-
document, it's entitled Southwest Public Service Company's Response to Second I don't know what that part means, second reopen bench request order. But anyway, so bench request 1-1, ask Mr. Lowe to please provide the generation source. Okay, so you're generally familiar with the generation resources, correct?
Yes, those resources, yes.
Okay, and are those resources, are they all identified on your attachment 3, or are there some that aren't?
There are some that are not.
And explain why there's some generation resources on your attachment that are not listed on Mr. Lowe's DAL-1.
The items that are listed that I can see on Mr. Lowe's attachment are resources that are specifically owned by SPS with the exception of Black Hawk. The items that are in my map include all the remaining power purchase agreements and their locations generally.
Okay, who owns Black Hawk?
I unfortunately do not know off the top of my head at this time. I do not know the specific name of the legal entity.
Okay. Mr. Rodriguez, you've been the president of SPS for about a year now?
1 year and 20 days.
And how many hearings have you testified in that during that time?
I have not provided testimony in any hearings, nor have I testified live in the last year and in the last year.
So this is the first time?
I have provided written testimony on behalf of Puget Sound Energy. But as it pertains to my time at SPS, I have not provided testimony before.
Okay, so this is your first time to testify before the New Mexico Public Regulation Commission.
As a witness, yes.
So just in case you don't know all the rules, there's an unwritten rule, Mr. Rodriguez, that if you defer to a different witness, that means they get part of your salary. Do you know that?
That is I appreciate you informing me of the rule, Madam Hearing Examiner.
And we can probably clear that up because I have questions for Mr. Lowe. But Ms. Kane, you can note down that bench request 1 is that I would like to know who owns Blackhawk 1, and it does, like say, if we can get that sooner through a bench request, we'll do it that way.
So noted, Madam Hearing Examiner.
I think really that's all the questions that I had for you, Mr. Rodriguez. Again, just trying to get the idea of the purpose and some specifics on your testimony. So I thank you, sir. Commissioner Ellison, did you have any questions, sir, for Mr. Rodriguez?
Yes, just a few.
Please go ahead, sir.
Good morning, Mr. Rodriguez. Thank you for being a witness today.
Good morning, Commissioner Ellison.
I'm fairly new here as well, so I haven't been in many of these more than you have. So we're in a similar situation in that respect. Your last rate case was approved in February of 2022 by the commission. Is that correct?
That is my understanding. It preceded my time specifically with the company.
Okay. Why is it that you filed another rate case so soon?
One of the items that we note is that the cost of providing service is something that we are mindful of. We also recognize that there are requirements of the state of New Mexico for us that we must meet, as well as providing service to our customers and the system as a whole. So we also are mindful about maintaining the reliability of that service. And we also, as part of this case, requested a future test year, and that regulatory innovation, which we have settled on in this case, is another item that provides a benefit to our customers, and so that we can continue to provide reliable service consistent with the New Mexico Energy Transition Act.
Okay. So you've entered a rate case less than a year after receiving the previous decision. When do you think that you'll file your next rate case?
I will need to consult with our financial team in order to have a specific answer. But I recognize that the future test year provides a degree of certainty that we have not previously had. Also, there have been capital additions that we have made from the time that we had our last rate case to the time that we filed this rate case that we sought for inclusion in rate base. So those items are also new, but I would specifically seek to consult with our financial team, but the future test year does provide us that degree of certainty.
Thank
Mr.
you.
Rodriguez, do you have an idea
Unfortunately, Madam Hearing Examiner, I don't have a specific timeframe. I would have to follow up on that.
Well, you're familiar, sir, with aren't you, that SPS came in 2019, in case number 19-00170. And they came in case number 20-00238, which Commissioner Ellison just referenced. And both of those rate cases occurred primarily to put Hale and Sagamore wind facilities into rate base, correct?
That is my understanding, as well as the change in wholesale load for the company.
So those had specific purposes, and then you're back now for, according to the testimony, more capital additions, correct?
Among other things in the case, Madam Hearing Examiner, yes.
So I just wondered that since it appears that all three of these cases have stipulations, all three of the cases were settled for less than the revenue requirement requested, whether or not there's now going to be a fourth one to try to recoup whatever SPS feels like is in excess of the $93 million that you got in the other cases.
We would also follow whatever is required by New Mexico statute related to the application of the future test year.
Thank you, sir. Thank you, Commissioner Ellison. Go ahead, sir.
Of course. Regarding the Tolk power plant, which I understand is in Muleshoe, Texas, which I've driven through on several occasions, has the Texas PUC authorized abandonment by 2028?
We have a request pending for the treatment of Tolk Power Station with the Public Utility Commission of Texas in a pending proceeding. There has not been a final response from the commission at this time.
I see, but otherwise, do they, I guess, are they considering that your abandonment would happen by 2032?
Under Texas proceeding, it currently has a end of life scheduled for 2034, which differs from the current 2032 in New Mexico. And we are seeking to reconcile those dates for a retirement date of 2028 in both states.
And do you believe that a retirement by 2028 would be in the best interest of ratepayers?
Yes. Given the changes in tax laws, given the available resources that we have, and given the requirements of the New Mexico Energy Transition Act, there are benefits for customers with a retirement date of 2028 for Tolk generating station.
And can you briefly outline how that would save money?
One of the items that we have is we are mindful about the maintenance and capital expenditures that would be necessary in order for customers to have the benefits of the reliable service for Tolk generating station beyond 2028, especially in light of the costs associated with extraction of the limited water resources that are at the plant. So while it could arguably be possible to run the plant beyond that date, the costs associated with the extraction of the water would make it extremely expensive in order to run. And as a result, that would cost customers.
Okay, thank you. Shifting gears somewhat, where do you see your primary load growth coming from in your New Mexico service territory?
Many of the projections that we currently have show that Southeast New Mexico is expected to experience significant growth in load for SPS. That would be around the Carlsbad and Hobbs areas specifically, though that is not exclusive of all the towns in that area.
Would that primarily be from the oil and gas industry? I guess I understand that a lot of the oil and gas production is supported by diesel generation. Would that be a transition to power supplied from the grid?
That is part of it, and a significant part of it. It is the oil and gas industry that is not only expanding on its own, but as you mentioned, the electrification of their machinery in order to extract oil and gas. There are also other industries that are supportive of the employees that are moving to the area outside of oil and gas that are providing services that also increase the load in the area. And there are other industries just in general that find the area attractive in the SPS service territory and seek to relocate not just to Southeast New Mexico, but across the entire SPS area.
Okay, thank you. You mentioned that average rates for SPS in New Mexico are below the New Mexico average. If we focus on residential rates only, how do they compare with rates in New Mexico?
I unfortunately do not have the specific residential rate calculations in front of me, but I do recognize that we are competitive among residential rates for the state of New Mexico.
Okay, great. That's all the questions I have. Thank you, Mr. Rodriguez.
Thank you, Commissioner Ellison.
Mr. Rodriguez, just to clarify for the record, when you referred in your answer to Commissioner Ellison's questions, a Texas proceeding, are you specifically referring to Texas proceeding number 54634, which was filed with the Texas Public Utility Commission?
That would be, I'm sorry, Madam Hearing Examiner, you cut out. Can you please say the case number one more time?
54634.
Yes, that is correct. That is the request for SPS to change rates in the state of Texas.
My understanding that's SPS has asked for $148,495,826 revenue rate increase.
Unfortunately, I do not have the Texas proceeding in front of me, Madam Hearing Examiner. I'm focused right now on New Mexico.
Okay, subject to check. That was a revenue request, approximately a 20.6% overall revenue increase. That ring a bell?
Unfortunately, Madam Hearing Examiner, I don't have those numbers right in front of me.
Okay, but you're licensed in Texas, and pursuant to the way that Texas is required to do its rate cases, a decision is going to have to be issued in that case by the end of September, correct?
Based on my experience practicing in Texas, and I am not SPS's attorney in the case, those timelines can be extended in the state of Texas, and by practice, they generally are.
Has SPS filed a stipulation in that case?
There is no stipulation pending in the Texas case at this time.
And are you familiar with Texas proceeding 51802.
Unfortunately, I do not recognize the docket number.
Okay. I would represent to you that it was another rate case in Texas that an order was issued in May of 2022 that I believe there was a stipulated case in Texas. Are you familiar with that?
I am generally familiar with the cases that SPS has filed in order to address the decrease in wholesale load. But that case specifically preceded my time with the company.
Okay, so you're not familiar that that was an $88.5 million black box revenue increase that SPS had agreed, at least for purposes of AFUDC, at item 63 of the commission order issued May 20th. In that case, an ROE of 9.35 and a WACC of 7.01.
I am generally familiar with the cases in reviewing them for my role, but I don't have the specific information related to those cases. I just know the capital expenditures and the wholesale load changes of what has necessitated a number of the cases, including the Hale and Sagamore facilities.
Well, in your role as the president of SPS and having multi-jurisdiction responsibilities, do you try to do things similarly in both jurisdictions, or do you have a different philosophy?
We generally try to operate and consistently across both jurisdictions, because we operate one system across two jurisdictions.
It used to be that the commission was able to make a characterization of how much of a particular multi-jurisdictional utility like SPS or El Paso Electric was in their respective generations. Can you make such a characterization for the commission to put things in perspective?
I'm sorry, I did not understand the question. A characterization
of how much of SPS's business is in one jurisdiction or the other?
Those are the jurisdictional allocations are specified in the testimony of Mr. Luth, which has been adopted by a subsequent witness, but they are generally about roughly equal between the two jurisdictions.
When you say the jurisdictional allocations are done based on energy usage, aren't they?
Energy usage, and recognizing that as we evaluate where much of the load growth is occurring, that factors into a rate case like that we have here with the state of New Mexico, which has a future test year. Texas does not have a future test year regulation.
Texas doesn't have any renewable portfolio standards regulations, do they?
There are some RPS standards for Texas, but they differ from the way that they are applied and the way in which they operate compared to New Mexico.
Does Texas have anything equivalent to the Energy Transition Act?
That while Texas does have its own environmental laws, the New Mexico Energy Transition Act is specific to New Mexico, and I'm not aware of Texas having any type of similar law.
While the jurisdictional allocations might be equal, are the number of customers or the type of customers in Texas similar or different than New Mexico?
I would broadly note that we have similar industries across both service territories, and that the customer counts are roughly equal. However, I do recognize that we do serve the population center of Amarillo, which has approximately 200,000 residential customers, and our Carlsbad, Hobbs, Tucumcari, Clovis, and our Artesia are of different size, but combined, they create a large population. Unfortunately, I do not have those numbers directly in front of me.
Thank you, sir. Mr. Chairman, did you have questions for Mr. Rodriguez?
Thank you. Yes, I do.
Good morning, Chair O'Connell.
Hey, good morning, Mr. Rodriguez. Just have a few questions and kind of a higher level, I think, than maybe what you've gotten so far. But let's just starting with page 1 of your direct testimony. Can you provide a little more color or more detail on what your role as president at SPS requires?
Yes, as noted, I am the president and in charge of Southwestern Public Service Company. It is a subsidiary of Xcel Energy Incorporated, of which I sit on the executive committee of Xcel Energy Incorporated. And I oversee many of our external facing operations, but recognize that I am the executive and an officer of the corporation that oversees as well as the operations and financial aspects of SPS.
Thank you. And then in terms of overseeing operations at SPS, does that include things like strategic direction for SPS?
Yes.
And then how autonomous is SPS within Xcel's family of utilities?
We are separate operating companies. So for example, Public Service Company of Colorado provides service, electric and gas service to residents in Colorado. We provide our electric service only in Texas and New Mexico. And there is another separate operating company that operates in Minnesota and Wisconsin with service to some of the neighboring states, but they are separate entities.
Okay, thank you. And then in terms of setting strategic direction, then how do you hold the operation accountable for following that direction?
I apologize, Commissioner. I don't know if I understand the question. How...
I'm just broadly asking, are you the boss of everybody at SPS?
I am the responsible officer for SPS, and I am the person who has, for which there's direct reporting authority for a number of folks specific to the operating company.
So in terms of like individual goals of your direct reports, you participate in goal setting and
yes.
And like annual reviews, bonuses, that type of thing.
Yes.
Thanks.
We also coordinate where necessary for those entities that report to Xcel Energy Services Incorporated.
Oh, thank you for that. And then is the goal of that to help propel the action of SPS along the path of the strategic direction? Or is there another goal, whatever?
Yes, consistent with the expectations of the states in which we operate.
Thank you. Okay, so if we could turn to page 2 on your direct testimony, line 3. Just broadly want to understand what your view is of SPS leading the clean energy transition.
As noted, we have talked earlier about Hale and Sagamore wind facilities. Those were two large wind facilities for the benefit of our customers in the SPS system. One located in Texas, one located in New Mexico, but both benefiting customers across both states. And as part of Xcel Energy Incorporated, we are operating consistently with bringing on new types of renewable resources that before other companies have engaged in similar processes. And I also note that we are meeting our requirements under the RPS and the ETA in the state of New Mexico.
Okay, so what I heard was leading in adding renewable energy. Does Xcel or SPS have any other clean energy goals?
I recognize also that we have a clean fuels goal, and we are evaluating the type of resources that we could use to power dispatchable generation. My colleagues at other Xcel companies have natural gas systems for which we could benefit by understanding the technology that they would need for a local distribution company, but which we do not operate specifically at SPS.
Okay, so the reason I was fishing around with that question is, I went and visited Xcel's webpage last night, and there's a lot in there about leading the clean energy transition. And the focus on that is a zero carbon goal in 2050. So is that part of SPS's remit?
Yes.
And then is that goal expressed in terms of renewable energy or greenhouse gas emissions?
It is expressed in terms of greenhouse gas emissions.
And then could you describe what SPS's clean energy goal is within the larger goal of Xcel?
Our goal is to meet the same requirements that Xcel has. We recognize, however, that technology is going to impact us achieving that goal, as well as the regulation in the states in which we operate.
And then could you briefly tell me what Xcel's requirements are?
Xcel Energy has its own net zero carbon vision by the year 2050, zero emissions.
And when I was looking at the webpage, I also saw an interim goal of 2030. Does that relate to SPS?
Yes, it does.
And can you state for me what the SPS interim goal is?
Our goal is to be consistent with that of Xcel Energy Incorporated, and recognizing that the impacts of state regulation and technology could impact whether we can achieve that goal or not.
Yeah, what I saw online was a actual target of reduce emissions by at least 80% by 2030, reliably and affordably for customers.
Yes, that is our goal.
Okay, so SPS shares that goal.
Yes.
Then on your direct testimony, page 12, around starting on line 8, it talks about importance and emphasis in New Mexico with adoption of Energy Transition Act, which requires that renewable energy comprise at least 50% by 2030. So with that statement, are you intending to hear part of the law?
We intend to comply with the law as required in New Mexico, and where we can, we would like to exceed it.
Okay. And then just to be more specific, when I read that, my mind jumped to 62-16-4 renewable portfolio standard in the New Mexico law. And what I saw there was item 4, which is no later than January 1st, 2030, renewable energy shall comprise no less than 50% of each public utility's total retail sales of electricity to New Mexico customers. So do you agree with that?
I do not have the statute in front of me, but I note that we will operate consistent with the laws of New Mexico.
Okay. And so we've got XL goal that SPS shares for carbon reduction by 2030, and then also state law for 50% renewable supply by 2030. And then we'll, talked about how your goal is to comply with the law. Does that include all of the law?
Let me rephrase, Chair O'Connell, it is not our goal to comply with the law. Our intention is to comply with the law. We will work toward a goal, and while technology and regulation can impact it, our intent is to meet the goal.
Okay, thank you. Yeah, that was, you're anticipating a future question of mine, but. All right, so then within the law, there's a few provisions, obviously that 2050 is item 4. So there's a couple interim targets, there's 2015, 2020, 2025, 2030 is item 4. Item 5 is a target for 2040, legal requirement for 80% provided by renewable energy. But then the one I really wanted to talk about is item 6. So it says no later than January 1st, 2045, zero carbon resources shall supply 100% of all retail sales of electricity in New Mexico. Reasonable and consistent progress shall be made over time toward this requirement. So I am inferring from what we just said that it's the intention of SPS to comply with that law also.
Yes. And that may be an example where the state of New Mexico is operating faster than the national corporate goal of Xcel Energy Incorporated.
Yeah, understood. And I'm asking these questions because it gets a little confusing in some other testimony I read from SPS witnesses, whether that's what the law really says or not. And so just trying to set a foundation that you as president of SPS, the intention is to comply with the law. And then the other thing to explore here for me anyway is, would you agree there's a difference between, or is there a difference between renewable energy supply and zero carbon emissions?
Yes, that is my understanding.
So complying with the law in 2045 might take different action or action in addition to adding renewable energy. Is that correct?
That is correct.
So then going back to what we were talking about before, that you're responsible for strategic direction with SPS and leadership. A goal of it is to propel action of the organization. What plan or strategy does SPS have to back up this intention to comply with the law?
As part of what we are operating right now, we have our integrated resource plan process that we are following in New Mexico so that we can look for resources in the later part of the decade. As it pertains specifically right now, we have announced that the results of a request for proposal is to add more solar and for us to explore the integration of battery onto the system.
So in those planning processes, is there any weight or importance given to that 2045 zero carbon target that says reasonable and consistent progress shall be made over time towards this requirement?
As we operate our IRP processes and our resource planning, we are mindful of the requirements of the state of New Mexico and integrate those into our planning.
So could you just define for me what you think reasonable and consistent progress means?
Recognize that much of that can be dependent on technology, evaluating also the costs. And this is where we take the commentary from parties in the integrated resource planning process, as well as the commentary from our regulators such as yourself, as to understand the direction that we are moving A key factor in much of this is reliability as well.
So I guess is the answer to that, yes, that you plan for reasonable and consistent progress towards this net zero requirement? Or do you have a strategy to do that, or?
Yes, in fact, as you know, or as we've discussed, we're adding, or our intention is to add solar and to explore battery to integrate onto the system. We have added the wind resources of Hale and Sagamore already. And we are sensitive to the way that affordability and reliability play into it, which I would surmise informs how we define reasonableness as a state in the state of New Mexico.
Yeah, thank you for that. And then, I mean, going back to Xcel and SPS's 2030 target, do you have a strategy or a plan to get to that 80% carbon reduction by 2030?
That is the part of the IRP that I have discussed, the addition of the resources, and also evaluating the electrification of vehicles where it makes sense to do so.
Yeah, I guess where I'm struggling still is I'm hearing things that are easily quantifiable in terms of I added renewable energy, there are more electric vehicles. But is there a plan or quantification, some way to hold the organization accountable for reasonable and consistent progress towards the carbon reduction targets?
I do know that when we do file our RPS standards with the state, that is to make sure that we are aligned with the state as we move in the direction of meeting the requirements of the ETA. So Chair O'Connell, this is where we collaborate with the commission to seek advice and to understand the state of New Mexico's perspective for us to move in the direction, especially as we weigh reliability and affordability and to move in this direction.
Yeah, I appreciate that. And so I'm just, my familiarity with those plans, it doesn't include anything to hold people accountable for around carbon reduction.
As one of the items that Xcel Energy has, which is, and I will defer to how it is specifically addressed in its proxy statement, but there are some compensation aspects related to achieving clean energy goals for the corporation as a whole.
Yeah, that's good to know, and I'll go look at that. But again, just trying to look at in the context of this rate case and this stipulation, where some of the criticism is that it allows maybe some backsliding on CO2 emissions, how that fits within Xcel's corporate goal, the state law, and then big question is that in the public interest?
This is one of those situations where we are mindful about reliability and affordability. And while it may not necessarily be a straight line, which is not how I fully understand it, the recognition is that we would have a plant retired, if we're talking specifically about Tolk, by 2028, especially sensitive to some of the operational costs and limitations. And in order to maintain reliability, the extension of Nichols, which allows us to maintain a reliable system in the short term as we move toward meeting the requirements of the ETA and achieving and striving to achieve the goals of Xcel Energy Incorporated.
Yeah, I appreciate that. And just, I'm coming at this with my background as an engineer. So whether it's a straight line or a postal function, or we're going to increase so that we can decrease, I have not yet seen that anywhere coming out of SPS or Xcel. And it's frankly making it difficult for me to evaluate the stipulation.
Understood, Commissioner, Chairman, and recognize that we are and we will meet the requirements of the ETA. Our actions are done consistent and in an effort to meet those requirements.
And then, there seems to be some discussion or controversy around reasonable and consistent. So that's why I appreciate your comments on that. I guess in that instance, simple mind, I just open a dictionary when I don't have we don't have a rule. All we have is the law. And then Excel, despite claiming to be a leader, has not provided a plan that helps me evaluate that. So anyway, just coming from there, if the dictionary defines reasonable and consistent, how would you feel as a leader holding people accountable if they come in and say, hey, boss, we're going to meet this target by going the opposite direction?
Chairman, I also recognize that there were a number of parties who have maybe their own nuanced evaluations of reasonable and consistent, who we negotiated with in the course of this case, who have the perspective of consumers like the New Mexico Attorney General, the staff of the commission, the Sierra Club, who have joined the settlement. And so I note that any nuance in the definition is shared by the vast majority of parties in the case, and that as has been shown in our prior proceedings, we are exceeding the requirements of the statute. Our intention is to continue to do so.
Thank you. I appreciate that. Well, thank you, Ms. Hearing Examiner. I don't have any further questions, and thank you, Mr. Rodriguez.
Thank you, Chairman.
Thank you. I believe I've got almost 11:15. Might be appropriate to take a 10-minute recess. We'll come back and any cross-examination from, or not cross-examination, any redirect from SPS. So we're going to take a 10-minute recess. So
Sorry,
please remember that we are live streaming. So if you don't want YouTube to pick up any visual or audio during the recess, you'll need to take care of that. We're recessed.
Hearing examiner, can I ask a question?
We're recessed.
Okay, I'd like to ask a question when we come back.
Okay. It looks like our recess is complete. We are back with witness Rodriguez. And I believe Ms. Lynch, previously having waived cross, you now have a cross-examination question for Mr. Rodriguez.
Yes, the commissioners raised a couple of questions that I had not thought about, so I wanted to request permission from you to ask Rodriguez a couple of questions.
Go ahead.
Thank you. The first question, Mr. Rodriguez, will take you back to an exchange you had with Commissioner Ellison regarding water. I'm going to characterize that part of the testimony. Otherwise, we may want to replay the transcript to get it accurate. But I believe that you stated that one of the reasons the company is seeking an earlier abandonment and retirement of Tolk is the concern SPS has about the availability of water. Is that correct?
That would be what I would understand was our testimony. Yes.
Okay. So is it true that under the company's plan to increase availability of the generating unit by 40%, the total water consumption at that target generation would be approximately the same with or without the earlier retirement?
I also recognize that there are water experts on which we rely, specifically the groundwater agency for that area. So my understanding is that we can safely and affordably utilize the plant from now until 2028. I would also defer to the direct testimony and the testimony of Mr. Belt, who was one of our witnesses on the case, who is a Chesapeake water expert.
Correct. And we'll be asking some questions of Mr. Belt, but I want to correct for the record now this question around water availability and the plans that SPS has for Tolk. The water availability constraint exists only if Tolk is operated at the increased use of it by 40%. Correct?
That is not my understanding. And again, I don't know the specific engineering aspects related to the water, groundwater.
Okay, I mean, I don't think this is very complicated. Another way of thinking about this question is, would operating the unit at a lower target generation level, perhaps under the current optimization plan, reduce water use?
It would be a contributing factor among all of the other parties that utilize the water in that area.
Okay, so then that would also reduce the risk that water is not available for the plant generation amount through 2028.
I'm sorry, I disagree with the characterization.
You would use all of the available water if you didn't operate Tolk at the planned generation of 4,000 gigawatt hours per year.
We are not the only entity utilizing the water, and we are not the only entity that is changing its operations in that area. So we are also subject to the interactions with other entities that use the groundwater in that area that we cannot specifically control, irrespective of our use.
Okay, do you know where the groundwater, the source of the groundwater? Do you know the source of that groundwater?
I know it is the name of
Ms.
the
Lynch, hold
Ogallala
on.
Aquifer, but
Mr. Rodriguez. Ms. Lynch, I think you're expanding what the commissioner asked. I think
Okay.
you've gone beyond the scope of his questions.
Okay, so the other questions that I had prepared include going back to Chairman Mr. O'Connell's questions of Mr. Rodriguez regarding some of the plans that SPS has for its infrastructure. And I am wondering, is SPS planning to invest in more gas infrastructure upon Tolk's retirement?
We do not have any specific plans for gas generation at this time, but they are all subject to subsequent all source requests for proposals.
Okay, and then regarding the questions that referred to the reasonable and consistent standard, would you consider it reasonable for SPS to conduct a thorough analysis comparing all resources? All potential generation resources?
I'm sorry, I do not understand the question in relation to.
What's being proposed here? You're aware of the analysis that was conducted in this rate case, correct?
We are mindful, yes, I am aware of some of the analysis, not the specific details, but we are mindful of the availability and the lack of availability of generation resources to meet the growing need for the service territory. And given the existence of some of these plants, that is why we view it as reasonable for us to be able over time to utilize the plants in order to then subsequently consistently meet the requirements of the New Mexico ETA.
So would it have, because the ETA requires a reduction of carbon emissions or greenhouse gas emissions, would it have been reasonable here for SPS to have included renewable energy in its analysis?
We are evaluating the resources that are available given the time frame it takes in order to bring them onto the system, and what is available given our experience and the limited resources that are available at this time.
So here you did not model any renewable energy options for meeting any of the capacity demands outlined in this rate case application.
I am not.
Madam Hearing Examiner, can I object? I feel like we're going outside the scope, but she did not testify to modeling when he was being questioned by the commissioners.
No, this is just general. I think anyone aware of SPS's application would know the types of analyses run. I'm not asking specific modeling questions.
The objection is you're going outside of the questions that the chair asked. Do you have a response to that, Ms. Lynch?
I am simply asking if it's reasonable whether the current application did not include renewable energy resources in any of its analysis.
The specific objection, Ms. Lynch, is that you're going outside of the questions that the chair asked. Do you have a response?
I do. No, I'm not going outside of Mr. Chair O'Connell's questions regarding reasonableness and consistency or consistent progress.
Ms. Kane?
When she's asking about considering alternative resources, she has not explained how that relates to reasonable and consistent process, which was not just, the issue of alternative resources and evaluations was not discussed by Chair O'Connell that I recall.
Chair O'Connell did discuss the resources required by SPS, and so and the resources proposed here, and so and he asked specifically about the reasonable and consistent standard, and so this question refers only to whether it would be reasonable to include a broad enough analyses, especially including renewable energy, as part of the reasonable and consistent standard.
I'm going to overrule the objection. Answer if you know, Mr. Rodriguez.
I would defer to the testimony of Mr. Ben Elsey, who has evaluated the alternative options.
Very well. Ms. Lynch, anything further?
No, no, and I appreciate you. I appreciate your time. Thank you, Mr. Rodriguez.
Thank you, Ms.
Hearing
Lynch.
Examiner Hurst.
Ms. Kane, any redirect for Mr. Rodriguez?
Madam Hearing Examiner, just very briefly.
Very well.
Thank you. Mr. Rodriguez, I want to briefly go back. You were discussing, I think, with the hearing examiner and the commissioners, the filing of this particular rate case. And are you aware of whether there have been changes to the jurisdictional allocations in the SPS service territory during the period that's relevant to this rate case?
Yes, Ms. Kane. In fact, as I noted in my comments to the Madam Hearing Examiner, it is my understanding that we filed these cases primarily because of the changes to wholesale load, and that has necessitated the company filing rate cases in Texas and New Mexico to make sure that the allocations are set appropriately.
Thank you. And you had a conversation with Chair O'Connell regarding the ETA and the corporation Excel stated goals regarding meeting carbon-free standards by 2050. Can you explain your understanding of the corporation's goals as it may relate to SPS's operation?
Ms. Kane, I understand that our goal for 2050 at Excel Energy is an enterprise-wide goal. So some operating companies may be able to achieve a specific standard, others may not, but as an enterprise, it is the goal. And again, it is aspirational because it is all subject to technology, some of which does not exist at this time. The enterprise achieving those goals on the aggregate.
Thank you. And finally, you'd had a back and forth with Chair O'Connell regarding the concept of reasonable and consistent progress over time under the ETA. And I know there was some discussion about the operations of the toll plant, perhaps as it's been, being proposed and discussed in this case. And can you explain for the commissioners and the hearing examiner your understanding of the relationship between the reasonable and consistent progress standard over time and what SPS is proposing in this case?
Yes, Ms. Kane. In fact, what I recognize is that we have limited technology today, and over time, we will be meeting requirements and striving to achieve goals as some technology develops. And that is why we are working on the innovative aspects of those as an enterprise. I recognize, however, that in the interim, and this is why the term reasonable is particularly key, it has to take into account the available technology, the regulations under which we operate in New Mexico, as well as reliability and affordability, which as long as we are moving in the direction of directionally to achieve a particular goal, I recognize that there could be changes to emissions. I also note that much of the opportunity or availability of the plants is still going to be subject to the reasonable and consistent requirements that we have to operate as a prudent utility operator. And that is also consistent with the state and federal environmental laws as well. So that's one thing I want to note about the reasonableness aspect and us achieving these goals over time. It's not just one day to the next or instantaneous. It is over time, and we have goals. I'm sorry, let me restate that. We have requirements that we must meet.
Thank you, Mr. Rodriguez. No further questions, Madam Hearing Examiner.
Thank you. I just have two follow-ups, I believe, Mr. Rodriguez. In your opinion, who is the most knowledgeable witness to answer questions about the SPP from SPS's perspective?
Madam Hearing Examiner, I'm not trying to avoid this, but I would state that it depends on the specific aspects of the SPP that you're delving into, but otherwise I would note that Ms. Trammell is our policy witness and can discuss the general policies related to SPP. As the question would pertain to more specific aspects, Mr. Elsey would discuss aspects related to some of our generation resources in it.
Okay, thank you. My other question, you just were referring to SPS's loss of wholesale load as being a reason for I think probably not just having to have replacement generation, but also having to share the cost with the other ratepayers sharing the cost for the loss of that load. Correct?
That is my understanding, because we are required, my understanding is that those wholesale load contracts, we are required to allow them to expire from some prior rulings from years ago. And so as those contracts expire and we cannot renew them, we then have to reallocate the costs.
Well, hasn't, I mean, I know at least the past two, this case and the prior case, if not even the prior case. So 19-170, 20-238, and then now this case, I mean, how long is SPS going to keep claiming loss of wholesale load? I mean, doesn't there get to a point where you can't use that as a justification anymore?
Those cases are consistent with the timing of the expiration of the of the wholesale contracts. So we do not dictate the timing of the expiration of those contracts. Those contracts expire on their own terms.
Well, for example, I mean, it's been a number of years since SPS lost the co-ops, hasn't it?
There are still some co-ops that take wholesale load on the system.
But for the ones that left the system, it's been a few years, hasn't it?
If their contract expired at that time, then that would be consistent with the timing of that particular case. We still have others in New Mexico that are part of the system.
Well, and for example, with the Lubbock Power and Light issue, I mean, it's been a few years since they dropped the full requirements contract, hasn't it?
A portion of the load, that is correct.
Right. And so now they're on this partial requirements that, according to the SPS testimony, now they want to terminate that contract. And I think get their power from ERCOT?
They will be joining the ERCOT grid and leaving the Southwest Power.
Right. So, I mean, I understand that there's a transition period, but it seems like to me that SPS has been using this justification in the past three rate cases, and I just wondered, is there going to be an end to this or not?
When the last wholesale contract expires, Madam Hearing Examiner,
okay,
that we're subject to the timing of the expiration of those contracts, from what I understand.
Are you actively seeking to replace those wholesale loads?
As I noted, it is my understanding that the company is subject to some prior rulings from years ago that require us to allow these contracts to expire, and that we cannot renegotiate extensions or subsequent contracts.
Okay. Since part of the claim in this rate case is an increase, as you testified earlier this morning, SPS is projecting increased load growth in southeastern New Mexico service area, correct?
That is correct, Madam Hearing Examiner.
Do the two don't meet? Is that what you're saying?
I don't understand specifically about the two not meeting. I know that we filed the case to recognize the decrease in wholesale load, which is one factor of reallocating those costs. But the case also notes the new capital infrastructure that we have had to put onto the system since we filed the last rate case. And because this case pertains to a future test year, it also recognizes the projection of the load growth and costs that we are going to incur in order to meet those requirements.
So it's not that simple as saying that an increase in energy sales from one area or one type of customer equates to the loss of potentially a different type of customer, even if the amount of energy being utilized was similar.
That's right, because you have an allocation that needs to be redistributed on top of capital expenditures and the recognition of costs in order to meet the growing service load. So it is not just one item, it is one among other factors.
Thank you, sir. Commissioner Ellison, anything further, sir?
No, thank you. No, thank you, Madam Hearing Examiner. I'm good.
Thank you. Mr. Chair, anything further for this witness?
No, thank you.
Thank you. Anybody have any questions based upon my two questions? Hearing nothing. Very well. Mr. Rodriguez, thank you very much, sir. You are excused.
Thank you, Madam Hearing Examiner. Thank you, Commissioner Ellison. Thank you, Chairman O'Connell.
And if you could just exit the Zoom. Thank you. Ms. Hardy, you have another witness.
We do, Madam Examiner. Our next witness is Ms. Brooke Trammell.
Very well. And will you or Ms. Kane or someone else be offering this witness?
I will be offering Ms. Trammell.
Okay. All right, I am noticing that some of the party council are there. You are very good. Thank you. Okay, Ms. Trammell, good morning.
Good morning.
Ms.
In New
Lee,
Mexico.
Mr. Lee, would you please swear in the witness?
Ms. Trammell, would you please raise your right hand? You solemnly swear the testimony you're about to give the matter not pending should be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you, ma'am.
Thank you, sir. Ms. Hardy?
Thank you. Ms. Trammell, can you please state your full name for the record?
My name is Brooke Trammell.
By whom are you employed and in what capacity?
I am employed by Southwestern Public Service Company as Regional Vice President, Regulatory and Pricing.
Do you have a document in front of you that is marked as SPS Exhibit 6?
I do.
Can you identify that document?
This is my direct testimony filed in this proceeding on November 18th, 2022.
Was it prepared by you or under your direct supervision?
Yes, it was.
And is that also true of the attachments to your testimony?
Yes.
If you were asked the questions in your direct testimony today, would your answers be the same?
Yes, they would. Although I would note we have adjusted our requested base rate revenue increase in this proceeding through the processing of the case.
Madam Examiner, with that, I would move the admission of SPS Exhibit 6.
Any objection? Just because I was writing there, Ms. Trable. True and correct to the best of your knowledge?
Yes, Your Honor.
And if you were asked the same questions today, would your answers be the same?
Yes, Your Honor, although I did note that through our corrections filing and through our rebuttal case, our base
Sure.
rate revenue request has changed.
No, and I heard that. I'm just trying to make sure that you wouldn't all of a sudden have a big change. And again, I understand that the testimony is in context to the end testimony that you offer in 9, but any objection to what's been identified as Ms. Trammell's? Ms. Trammell, you have exhibits to SPS Exhibit 6? Do you have any attachments?
I do have attachments.
And were those attachments prepared by you or under your direction and control?
They were.
And with the exception of the identification of witnesses on page 131 of 195 regarding, that's your attachment 1. Mr. Luth's testimony has now been adopted by 2 other SPS witnesses, correct?
That's correct. Mr. Wesley Berger and Miss Debbie Gajewski have assumed the topics and materials that Mr. Luth previously sponsored in this proceeding.
Very well. The objection to what's been identified as SPS Exhibit 6, Ms. Trammell's direct testimony as just the attachment being corrected by her here today. Hearing no objection, SPS Exhibit 6 is admitted. Ms. Hardy?
Thank you. Ms. Trammell, can you please identify the document that's been marked as SPS Exhibit 7?
Yes, this is my supplemental testimony filed in this proceeding on March 27th.
Was that supplemental testimony prepared by you or under your direct supervision?
It was.
And if you were asked the same questions today, would your answers be the same?
Yes, they would. And attachments BAT2 SUP, BAT4 SUP, and BAT6 SUP were also prepared by me or at my direction.
And Ms. Trammell, some of the supplements have yellow shading. Can you indicate for the record what that indicates?
The yellow highlighting in all of our supplemental filing materials was meant to indicate where the supplemental filing changed a figure from our direct filing.
And what size font is that exhibit?
Which exhibit, Your Honor?
The BAT 6.
I think it's been prepared as Times New Roman 12. The printing of the document may have reduced the overall print size on the sheet so that it could print correctly with those columns.
Just as a recommendation for any party in the future, if I have to use this to read your exhibit, it diminishes the importance of your exhibit in my mind based upon the irritability factor. Okay.
Duly noted, Your Honor.
I can tell you for anyone that's a P&M customer, I have a new P&M case. After having difficulty opening the bill and not being able to read the notice, yes, I do read the notices in the bills. In your latest bill, you will find a notice for a battery case with P&M where they were specifically prohibited from having any font less than 10 point equivalent to 10.5 in Times New Roman for their notices. So just a word to the wise. Okay, back to SPS Exhibit 7, Ms. Trammell's supplemental testimony. It's been offered, Ms. Hardy?
I would offer the admission of the exhibit if I have not.
Any objection to what's been identified? SPS Exhibit 7, Ms. Trammell's supplemental testimony. Hearing and no exhibit. SPS Exhibit 7 is admitted. Ms. Hardy?
Ms. Trammell, can you please identify the document that's been marked as SPS Exhibit 8?
This is my rebuttal testimony filed in this proceeding on May 10th.
And are there attachments to that testimony?
Yes.
Was the testimony, well, were the testimony and the attachments prepared by you or under your direct supervision and control?
They were, I would note, 3 of the original rebuttal attachments were copies of my testimonies filed in another proceeding, and I understand we have addressed the status of those documents in this proceeding at the request of hearing examiner Hurst.
And so those were not included with your exhibit that was submitted into the Dropbox, is that correct?
That's correct.
Are the answers, or the questions and answers in your rebuttal testimony, let me ask it this way. Are the answers in your rebuttal testimony still true and correct?
They are. I would note any references in my direct testimony to BAT R3, BAT R4, BAT R5 would need to be recognized as amended, given that we did not include those attachments in the hearing exhibit submitted into the box.
With that, Madam Examiner, I would move the admission of SPS Exhibit 8.
Ms. Trammell, did you do a verification for that testimony? I see a lot of other verifications that are attachments.
And just to clarify, Your Honor, you're referring to SPS hearing exhibit 8.
No, it's actually, well, I'm zooming through, and I think they're in 6. So is your verification before? Because right after 6 is a certificate of service.
My verification for the rebuttal testimony that I filed in this proceeding, SPS hearing exhibit 8, is included at page 132 of that testimony. But Your Honor, if you're referring to SPS hearing exhibit 6, I need to flip back and look at that, which would be my direct testimony.
Oh, there it is. Okay. That's what I needed to know. No, it's the verification, the bunch of verifications from how much money all your lawyers make per hour. That's what was attached at the end. I was just looking for your verification and I found it. So you answered my question. And again, the attachments to your rebuttal testimony were prepared by you or under your direction and control, correct?
They were.
Very well. Ms. Hardy, you have offered SPS Exhibit 8, Ms. Trammell's rebuttal testimony, correct?
Correct.
And just for clarification purposes, henceforth and previously, all of SPS's exhibits that are being offered are in fact the copies that were placed into the Dropbox, correct?
That's correct.
Very well. Hearing no objection, SPS Exhibit 8 is admitted.
Thank you. Ms. Trammell, can you please identify the document that's marked as SPS Exhibit 9?
Yes, this is my testimony in support of the contested comprehensive stipulation filed in this proceeding. This testimony was filed on May 26th.
Was that testimony prepared by you or under your direct supervision and control?
Yes, it was.
If you were asked the questions in the testimony today, would your answers be the same?
Yes, they would.
And with that, Madam Examiner, I would move the admission of SPS Exhibit 9.
Any objection to what's been identified as SPS Exhibit 9? Ms. Trammell's testimony in support of the stipulation the attachment to the stipulation Ms. Trammell, did you prepare that?
Prepared it in conjunction with members of the revenue requirements team. It is a summary of the stipulated base rate revenue increase.
So who would you refer me to for questions concerning this attachment and stipulation Exhibit A as the appropriate witness?
Depending on your question, Your Honor, there's likely a few witnesses. Obviously, I am testifying in support of the stipulation and the overall $33 million base rate revenue increase, which is noted in both my attachment BAT Step 1, as well as the Exhibit A, which is included in the stipulation. Mr. Wesley Berger, witness for SPS, sponsors the present revenue calculation for the future test year period, and SPS witness Ms. Stephanie Nemi sponsors the revenue requirement calculation of the $33 million base rate revenue increase in the stipulation. But collectively, the three of us, I believe, can address your questions with regard to stipulation Exhibit A.
Very well. Any objection to what's been identified as Ms. Trammell's stipulation testimony, SPS Exhibit 9? Hearing no objection, SPS Exhibit 9 is admitted. Ms. Hardy?
Thank you. Ms. Trammell, can you please identify the document that's been marked as SPS Exhibit 10?
This is my rebuttal testimony in support of the contested comprehensive stipulation filed in this proceeding. This document was filed on June 9th.
Was that testimony prepared by you or under your direct supervision and control?
Yes, it was.
If you were asked the questions in that testimony today, would your answers be the same?
Yes, they would. And I would note there are no attachments to my rebuttal testimony in support of the stipulation.
Thank you. Madam Examiner, with that, I would move the admission of SPS Exhibit 10.
And your answers are true and correct to the best of your knowledge?
Yes, Your
Ms.
Honor.
Trammell? Any objection to what's been identified as SPS Exhibit 10? Ms. Trammell's rebuttal testimony in support of the stipulation. Hearing no objection, SPS Exhibit 10 is admitted. Ms. Hardy?
Thank you, Madam Examiner. I have no further questions for Ms. Trammell. She's available for questions.
Very well. I believe that the only party that reserved any time for a cross-examination for Ms. Trammell was CCAE. And is that correct, Ms. Lynch? You
Yes,
reserved
correct.
40 minutes for Ms. Trammell.
Yep.
Please proceed.
Okay. Hi, Ms. Trammell. It's nice to see you again.
Likewise.
Thank you. To begin, I just wanted to gain an understanding from you about CCAE's position. Is it your understanding that CCAE's position for Tolk includes supporting early retirement of Tolk at 2028, but assuring that the public that Tolk will not be operated at 4,000 gigawatts per year and would instead be operated at 2,400 gigawatts per year?
Generally, that's my understanding of CCA's position, which would result in less customer savings as we've modeled available to retail customers.
And is it also true that CCAE is asking SPS to seek more renewable energy to meet the added demand for Tolk and Nichols?
Can you clarify what you mean by added demand for Tolk?
I think it's the needed load or your load management.
So the retirement request in this proceeding for Tolk generation is not directly related to any load that we've identified. It's a unit on our system, but I'm confused by your reference to the load with respect to CCA's position in this proceeding.
For Nichols. I mean, you've identified a needed capacity and therefore you're extending the lives of Nichols, the Nichols units.
Yes, but our extension of the Nichols units is related to the increase in the SPP or Southwest Power Pool planning reserve margin requirement. It is not presented in this proceeding as a result of load increases.
And the need for Tolk is unrelated to that reserve margin.
I would disagree with your general statement. Tolk is about 1,000 megawatts of capacity on our system. It's absolutely needed to contribute to us meeting our capacity reserve margin requirement.
Could the extensions of Nichols be used to meet any required reserve margin need by SPP?
Yes, and it has, because the SPP's increase in the planning reserve margin was effective in 2023.
Okay. Is it your understanding that CCAE also supports the inclusion of an EAP in this stipulation? An energy affordability program that you proposed?
It's my understanding that CCAE is not supporting the stipulation, so I would disagree that CCAE is advocating that be included in the stipulation. I understand CCAE's position to be more removed from the stipulation than that, but do agree that CCAE would like to see SPS implement an electric affordability program in New Mexico.
Could an EAP be included in a modified stipulation if that were the commission's desired path forward?
At this time, I don't know. The stipulation is an agreement among 10 stipulating parties as a whole. If the commission were to find that it disagreed with the legal interpretation of some of the parties in this case, and that an EAP were to be implemented by SPS, I understand that the stipulation would need to be revisited by all signatories.
So in other words, if the commission were to determine that the EAP is not unreasonably discriminatory and therefore not prohibited by law, is SPS still willing to implement the EAP that you presented in your application?
Again, that would need to be a discussion among all of the signatories. As a signatory to the stipulation, we support the stipulation as a whole. The EAP is a customer-funded program, so I have to recognize that we cannot solely agree to inclusion to the EAP in the stipulation without reviewing the cost impacts as a customer-funded program with the other signatories.
Okay, so if the commission modified the stipulation to include the EAP, is SPS willing to implement an EAP?
If we still had a stipulation at that point and it was approved by the commission, we as a company, again, separately from speaking on behalf of any of the signatories, are willing to implement an EAP in New Mexico.
Okay, thank you. Thanks for answering that from SPS's perspective. All right, we're going to transition to another line of questions. Is it true that SPS failed to evaluate the economics of continuing to operate Tolk under the current optimization plan through 2028?
I disagree.
Can you elaborate, please?
You characterize that as a failure. Our testimony in this proceeding is that that scenario was not modeled because that scenario is not in the best interest of our customers based on Mr. Elsie's updated Tolk analysis.
SPS did model this scenario through 2032 though, correct?
That's a question best answered by Mr. Elsie. I believe he had to have a base case in comparing the cost savings of the updated Tolk analysis, but he can speak to those specifics.
Okay. All of the scenarios that were evaluated by SPS were constrained to scenarios that utilized all the remaining water at Tolk, correct?
I don't know. You'll need to talk to Mr. Belt and Mr. Elsie.
Okay, I'm just taking some notes. So you are unaware of any constraints that may have been used for either of the scenarios?
Again, the other witnesses are more familiar with the details of the modeling.
Okay. So this is another modeling question. Should I defer to Elsie?
Most likely, but without hearing the question, I can't answer for sure.
Okay, I mean, you do discuss some of this in your own testimony, so I would expect you to be able to answer some of these questions. Why did SPS model Tolk at the highest generation of 4,000 gigawatt hours per year and not at a lower number?
The reason behind the earlier retirement of Tolk proposed in this proceeding is a reflection of higher gas prices that we've experienced on our system, as well as an increase in gas price volatility compared to the last Tolk analysis that was presented in SPS's last base rate case. In addition, with the passage of the Inflation Reduction Act, from a modeling standpoint, we expect that the replacement costs of generation for Tolk in the future will be less than has, again, previously been modeled in the Tolk analysis. So those two considerations change the economic analysis of Tolk's recommended retirement date, recognizing that Tolk is a lower cost energy resource compared to higher gas prices. It's more economical for our customers to run coal generation at Tolk when gas prices are higher. If you pair that positive economic result for customers with the expectation that replacement capacity in the future will cost less, we really for the first time have economic incentive to retire Tolk earlier. In other words, to utilize those more favorable economics for our customers rather than preserve the capacity value of Tolk as long as possible. So we have resources available in the remaining life of Tolk from a production standpoint, a plant capability standpoint. And so if we move the retirement date to 2028, again, to maximize the economic value, the economic analysis sponsored by Mr. Elsey supports increasing the generation, again, to increase the economic benefit in times of higher gas prices for SPS customers.
Would you say that, or have gas prices fallen since you submitted the application? And
they have moved around some. Again, the gas price strip modeled by Mr. Elsey is more than just the months since we filed the case, right? It evaluates gas price forecasts through the retirement date. So while there is increased volatility in gas prices in SPS service territory, we just remind the commission that the gas price forecast used in that analysis does go through the asset's proposed remaining life.
okay, so we're going to talk about the water. What is the source of the water that is used at Tolk?
It's my understanding that Tolk cooling water, processed water is sourced from what we refer to as Tolk wellfield. It's a series of water rights and SPS owned water wells in an area near Muleshoe. I say near, it's several tens of 20 miles away from the facility, but in context of our service territory, it's relatively close to the facility.
Is the Ogallala Aquifer the source of the water?
That's my understanding, the source of the well field and water rights that we have in that area.
Do any of the constraints that exist for the use of water from the Ogallala apply to SPS specifically?
What do you mean by constraints of the Ogallala Aquifer?
The use of the water from the aquifer?
Physical constraints,
so
permit
for example, the agricultural sector can't draw all the water it wants, and its rights may claim because those rights have been constrained. Has SPS's rights to the water in the Ogallala Aquifer been constrained at all, you know, in a similar way that the agricultural sector has had their rights constrained?
I'm not aware that the agricultural sector has any constraints in that area. Mr. Belt could confirm that. What we see in the Tolk well field, and as Mr. Belt testifies, is a very material decline in well field productivity. So it's less a question about water availability. We do note there's significant competition for water in this area, but the declines in the saturated thickness of the aquifer, as well as the declines in the well field productivity, raise concerns to the feasibility of water production for Tolk in the future.
Do you know whether for the Ogallala Aquifer there is broader public concern about the aquifer recharging?
I'm not aware. Mr. Belt may be best for that question.
Okay. This next question may be referred to Mr. Belt too. Do you know if the water SPS uses for Tolk could be reused?
Can you help me understand a purpose of the reuse of the water?
The current purpose to cool down your facilities.
It's my understanding that we are able to cycle the water multiple times at Tolk, as well as water through the generation at Plant X units. Again, Plant X and Tolk generally source their water from the same well field. SPS witness David Lau can speak to the specific process and water reuse within the generation facilities. And Mr. Belt can probably detail the water efficiency through those generation functions or generation processes.
Thank you. Thanks for that direction. All right, so we're still going to focus on water here, but the two scenarios that were presented and discussed in your testimony, in your opinion, could SPS have run an analysis to show a scenario where all the water does not get depleted, or all of the available water to SPS does not get depleted by 2028 or 2032?
Again, I disagree with the characterization that our modeling has shown depletion of the water resource in the area in either scenario. Mr.
Depletion
Belts,
of the water available to SPS. So I didn't say depletion of the water, because you could always invest in infrastructure.
Is that a question,
and
Ms. Lynch?
pumps.
Is that
Correct?
a question?
Yes,
You can't testify.
I'm asking whether SPS could, if SPS scenarios were run to show the use of all the water available to SPS, currently available.
I apologize. I don't understand your question.
Could SPS have run an analysis different from the ones that were run to show a scenario where SPS does not use all of the economical water available to it by 2028 or 2032?
And the reason I am struggling with your question is, again, as Mr. Belt testifies, we rely on the water surveys and studies. Mr. Belt has included those studies to his testimony. I guess I don't understand that what you're describing is how we've modeled the updated Tolk analyses.
The two scenarios that SPS presents, both of them result in SPS using all of the economical water available to SPS. Correct?
That's not my understanding. I think you should ask those questions of Mr. Belt, who sponsors the water analysis.
Okay. So, in your opinion, does risk to ratepayers increase if SPS runs out of economical water?
Can you elaborate on your question? I mean, that's a pretty
Essentially,
broad question.
the question is asking if the ratepayers would experience greater risk due to SPS using all of its economical water.
There's a remaining life of the generation facilities that we would manage. So risk would be mitigated in the management of the facility through its remaining life. As the unit nears retirement, we would be and are making plans to secure replacement resources for that facility. When you discuss risk, I assume you're meaning risk of SPS customers not having the capacity and energy resource of Tolk at some point in the future. And those are the exact risks that we're working to mitigate both in this rate proceeding as well as in our integrated resource plan currently pending before the commission.
Would it become more expensive to the ratepayers if SPS uses all of its economical water?
All else held equal, I'll say no, because we have invested in the facilities and the infrastructure to supply that water. Again, all else held equal, costs would not change.
Okay. So the next question refers to possibility of SPS's plans. Is SPS planning to expand or build out new gas resources to replace Tolk?
We expect that replacement capacity and energy for Tolk will be a mix of resources. It's likely to be a mix of renewable as well as firm dispatchable resources in the future. That portfolio won't be decided upon until the conclusion of SPS's 2023 IRP process.
Do you have any, based upon your experience, any estimate for the percentage that the gas could, gas infrastructure could be used to cover Tolk after 2028?
No, I don't have an estimate. Resource acquisitions in New Mexico are now under the new IRP rules required to be acquired through a competitive solicitation. So the ultimate composition of a recommended or preferred portfolio in the IRP process will be dependent upon the bids received in that competitive solicitation. So in other words, our resource mix to replace Tolk capacity will be entirely dependent on the resources submitted in that RFP and ultimately evaluated and chosen and then subsequently approved by the commission.
Okay, thank you. So this will be, this focuses more upon the economic dispatch of Tolk. Is it possible that economic dispatch of Tolk could be at 4,000 gigawatt hours per year?
Yes, it is possible, and that's what our modeling shows, that 4,000 gigawatt hours a year annual target for Tolk generation through its remaining life under the 2028 retirement proposal is the most economical solution for customers.
So can you describe what might make it possible to economically dispatch Tolk at that ratio, 4,000 gigawatt hours per year?
Yes, this is a formal process that we work through with the independent market monitor. It's a function within the SPP. We describe our limitations for a generation unit with the market monitor, and the market monitor works with us to assign what we call an opportunity cost adder. So the offer prices for generation units bid into the SPP are reviewed and have to be signed off or approved on by the market monitor. So for a Tolk example, when we have production that is restricted or reduced, the market monitor has to sign off on the offer prices that would result in a 4,000 gigawatt hour target. To say it another way, we increase the costs of the Tolk offer price to reflect that it cannot be economically dispatched beyond a gigawatt hour annual target.
Is it plausible that increasing generation at Tolk to the 4,000 gigawatt hours per year could cause the plant to run out of water sooner than expected?
No, again, our modeling utilizes the resources available through its remaining life, and that has that modeling and that optimization of our scarcity and limitation of resources for Tolk generation has produced the 2028 retirement date.
Okay, so you answered what could make it possible to economically dispatch Tolk, and we're going to explore what could make economic dispatch of Tolk impossible at 4,000 gigawatt hours per year.
Is that a question?
Yes, it is. What could make economic dispatch of Tolk impossible?
I don't understand your question. In that hypothetical, do you mean less than 4,000? Do you mean zero?
Hold on, you can't talk at the same time, okay? So let the witness finish her answer, please, and then you can clarify. Go ahead, Ms. Trammell.
Thank you, Your Honor. Ms. Lynch, that's a very broad statement. Are you asking if there's a scenario where dispatch would differ from a 4,000 gigawatt hour target, or that dispatch itself in its entirety would be zero? Is that what you mean by impossible?
I'm actually asking both. Are there
Okay.
scenarios under which the dispatch would be zero? And are there scenarios upon which the dispatch would be less than the require use of Tolk at less than 4,000 gigawatt hours per year?
Okay, in this hypothetical, and Your Honor, thank you for allowing me to ask a clarifying question. I know I'm supposed to be the one answering the questions, not asking them, but wanted to make sure I give the right info here. Probably the most clear example of when dispatch of Tolk would be zero would be after retirement and abandonment of the facility. Another example when not on an annual basis, but at a given point in time, dispatch would be zero from one or both of the Tolk units would be when the units are in synchronous condenser mode as opposed to generator mode. Another instance when dispatch would be zero is if the units have not been dispatched by SPP, who dispatches generation not only on our fleet, but across the 14-state SPP footprint. That security constrained economic dispatch, or SCED, that SPP refers to it as, again, is optimized at the level of the pool. So if Tolk is not being dispatched, it's usually a reflection of high penetration of renewables on our system in a given operating hour. Do those examples address your question, Ms. Lynch?
Yes, and I'm just wondering, based upon your knowledge and experience, is it possible that Tolk will not be used at the 4,000 gigawatt hours per year that is modeled by SPS?
It could be. It's relatively unlikely, though, again, because the offer price for the units will be formulated by the SPP market monitor to achieve a 4,000 gigawatt hour target, if that's the production limit that we work with the market monitor to plan for.
So it is your prediction that Tolk will be operated at 4,000 gigawatt hours per year?
Yes, if the commission approves a 2028 retirement date for the facility, and we continue to flexibly and economically dispatch the unit for the benefit of our customers.
Okay, thank you. Did SPS incorporate the impacts of climate change into any of its modeling of Tolk?
Can you clarify what you mean by impacts of climate change with respect to modeling inputs?
I think the science is clear on the impacts that climate change has on our different regions. SPS, and you specifically got up at the last commission meeting to discuss some of those impacts that climate change was having on some of the weather patterns in SPS territory. From off the top of my head, I can recite that the science concludes that there will be greater impact on our water resources, including groundwater resources. I'm just wondering, did SPS look at the effects of climate change in running any of the scenarios that it presented here in this rate case?
Madam Examiner, I'm going to object to that question. I think Ms. Lynch is testifying, and I think
No, I'm asking, for one, Trammell asked me to elaborate on what are climate change impacts, and my question was, did SPS incorporate any of, I can broaden it, incorporate climate change into its modeling of Tolk?
Ms. Hardy?
I think that's a more specific question than Ms. Lynch was asking previously.
The impacts?
So
Okay.
if that's the question, I think Ms. Trammell can answer if she knows, if it makes sense to her.
So you're withdrawing your objection?
Based on Ms. Lynch's revised question, yes.
Very well. Answer if you know, Ms. Trammell.
Thank you, Your Honor. From my perspective, our assessments of the reliability of a recommended portfolio or the reliability of a modeled scenario is the key modeling input or modeling consideration. In other words, we know we have capacity and resource adequacy requirements on our system, and we continue to model the availability of capacity on our system to meet those requirements. You noted the increasing effect of extreme weather on facilities. Again, from my position, you can speak to Mr. Elsey on modeling specifics, but from my perspective and my position, a focus on reliability and capacity preservation, as well as meeting resource adequacy requirements into the future, is a very strong and prudent utility planning decision with regard to the potential future impacts of climate change.
Does SPS have a regular system of evaluating the effects of climate change on its utilities?
I don't know what you mean by regular system. However, we do monitor the weather. We monitor the behavior of weather patterns in our service territories and across Xcel Energy's footprint. We have our own meteorology department, and we assess weather patterns over time, even in the rate making context through weather normalization adjustments.
Okay. Do you know what the cause of, one of the main causes or drivers of climate change is?
Yeah, I'm not an expert in climate science, so I would be speculating if I testified to that today, Ms. Lynch.
You don't know whether the increased greenhouse gas emissions resulting from utilities contributes to climate change.
Madam
Again,
Examiner, I'm sorry, I'm going to object again. I think these questions are outside the scope of Ms. Trammell's testimony.
Ms. Lynch, do you have a specific
right.
referral to SPS Exhibit 6, 7, 8, 9, or 10 regarding inquiry into these questions?
Yes,
subject-
there is very specific reference to New Mexico's Energy Transition Act, which requires SPS to hit certain targets on the reduction of greenhouse gas emissions from its utilities. And so I'm inquiring whether SPS or whether Ms. Trammell is aware of the greenhouse gas emissions and why we're moving towards zero emission.
Please give me the specific reference in Ms. Trammell's testimony that the
I will.
objection refers to.
That would be the Energy Transition Act. I'll have to pull up her specific testimony. Give me just a minute.
Okay, you're at 7 minutes left of your 40.
Okay, fantastic. I'll get back to you about where Ms. Trammell refers to the Energy Transition Act.
Are you moving on?
Yes, I'll need to
Go
move
ahead.
on in response to your comment about time. So my next question is, did the Encompass modeling that SPS ran include NOx emission allowance costs?
Yes, it's my understanding that we included NOx allowance costs associated with Group 2 emissions requirements, as we are currently subject to the Group 2 program under CSAPR.
Okay. Do you know if Tolk has firm and certain fuel supply through 2028?
We have a coal supply contract effective through 2027. Those costs and that information are actually presented in this proceeding, and we will be negotiating and extending the coal supply contract to cover the remaining service life of the facility. That contract will be negotiated after resolution of this proceeding, when a retirement and abandonment date is established.
Are the costs for extending that contract, how are they captured? How would they be captured?
Do you mean in customer rates?
No, will the cost for the needed coal go up if you expand or extend the contract?
That's impossible for me to state today. Those negotiations haven't occurred yet, and that would also be for a future period. Again, the contract we have in place today was effective January 1, 2023, and goes through the end of 2027. When I say that, I'm referring to the coal supply agreement. There are also other costs associated with coal operations at Tolk, as well as Harrington, while it's still a coal unit, that are reflected in that coal supply agreement. Things like coal handling, rail transportation, those kinds of things, beyond just the price of coal itself. So we have negotiated a known price for coal deliveries and coal supply to our facilities through 2027.
Okay, thank you. So again, we're going to go back to the modeling scenarios. The modeling options that SPS chose to use in this rate case relied upon Tolk operating under the current conservation plan until 2032, or the modified plan of increasing year-round operation of Tolk to 4,000 gigawatt hours per year through 2028, correct?
Yes, that's my understanding.
Does the stipulation present a different scenario than increasing year-round operation of Tolk at 4,000 gigawatt hours per year through 2028?
The stipulation memorializes agreement among the stipulating parties and the signatories that that scenario produces over $120 million in estimated customer savings for New Mexico customers, and the economic benefits of the earlier retirement date is supported by all the parties, consistent with SPS's analysis in this proceeding.
Under that scenario, does SPS plan to use all of the economic water available to it?
Again, I think we've talked about water availability versus water production versus water depletion, and I still maintain that Mr. Belt would be the one to discuss the specifics of our water projections and the water studies that he's overseen. But again, we are modeling water production based on the declines in the well field that we've seen, as well as our expectations of water production that would be needed through 2028 to support that 2028 retirement date.
So I guess as I've read the testimony, SPS plans to use all of that economic water available to it because it's most prudent for SPS to do so. Would it be imprudent for SPS not to use all of the economic water available to it?
Again, I disagree with the characterization of your question. We're not aiming to use up all the water.
Is
We're
it
aiming
possible
to-
that you will use all the economical water?
I don't know.
So I'll ask Mr. Belt about that too.
2 minutes.
Well, I am very pleased to give everyone 2 minutes back. I appreciate the responses, Ms. Trammell. It was very nice to see you.
Thank you, Ms. Lynch.
Thank you. It looks like it's 12:15. And I think it might be a good time to break for our luncheon hour. We will come back and I've got a few questions for you, Ms. Trammell. I don't believe anybody else reserved any time, so I've got a few questions, and we are well, again, remember about live streaming and YouTube. So I'm not going to shut it off during the proceedings. So We are recessed until 1:15. Thank you.
Thank you.
We're not going to use up all the water.
Okay. It looks like we are at 1:15, so I think we probably should be back from our luncheon recess. And depending on how I can get the technology to cooperate, looks like we have all the people. Not all the people are back. I think we still have Miss Beatles and Mr. Getco. Okay, well, I think we can go ahead. Are we going to have any procedural matters that we need to deal with at this juncture?
Madam Hearing Examiner, this is Joshua Smith on behalf of Sierra Club. Sorry to interrupt you about that. And I do have a procedural question for you. There is a possibility, I did not reserve time. We did not reserve time for Ms. Trammell. But I do believe that a couple of the questions that Ms. Lynch had posed in her cross-examination deserve some clarification. And I'm also anticipating that there might be questions that we would be interested in following up on based on your bench requests and Ms. Trammell's responses to those bench requests. So I guess I'm curious what your preference is in terms of how to approach that.
Well, normally what's going to happen is you get one more bite at the apple on the second go around. And so you can ask questions with regard to the cross-examination questions or my questions or the commissioner's questions on the second go around. Okay.
Yeah. Thank you for clarifying. Appreciate it.
Very well. Any other procedural matters? All right, let's go ahead. Good afternoon, Ms. Trammell. I do have a few questions for you. And we actually could start right there. That's one of my technology issues today, is that the little box that I was given as a in the office computer, I tried for from 7 to 7:30 this morning to try to install my wireless headphones from home, because I didn't want to use the one USB port, because that's where my downloads are on my flash drive. So I have a separate computer and I can't share screen from it. So I can try to bring this up on the commission's website.
Hearing examiner,
Who is speaking?
Stephanie Zur.
Hi, Ms.
Just-
Zur.
Good afternoon. Just a technical thing. If you do share screen, you could have SPS share a document that you ask them to put up on the screen. Just if it would make it any easier, I thought I would just mention that.
You know, I appreciate that. I'm very protective of my share screen. And normally people will tell you in the other cases, even though I don't send them an IT bill, which would be pretty funny, I usually bring up the exhibits myself, but I appreciate that that suggestion. Again, I'm I guess because that's why it's so funny that see me use two computers. It's not because I'm a Zoom whiz. It's just that I know how to use it, and I don't want to switch back and forth.
You could also log in as someone else on your other computer and join the meeting separately and share it on that computer.
And I may have to do that tomorrow, because the way that I am operating this right now is not real happy for me. So it's taking me longer to do this, but here we go. Okay. Okay. There we go. Ms. Tremble, can you see that?
Yes, I can, Your Honor.
Okay, so this is SPS's response to I think I've referenced this, I don't know what second reopen means, but to my June 12th bench request, correct?
Correct.
And I had some questions for you in that bench request, correct?
Yes, ma'am.
And we can start there. I ask you, about your footnote on page 26, footnote 11 on page 26 of your testimony in support of stipulation, which was SPS Exhibit 9, correct?
Yes.
Okay. And you had indicated in, in that footnote, in response to the question posed at lines 1 and 2, how would the resulting rates compare to other utilities rates, both nationally and in New Mexico? And then you responded from lines 3 to 5, inclusive of the rates under the stipulation and the associated reductions in fuel cost. So just so I'm understanding, this would be not just a looking at the rates increases, but you're actually looking at the rates in along with the reductions in fuel, correct?
Correct to an extent. I'll clarify to say that the associated reductions language there with regard to the fuel costs really is meant to capture that the fuel costs we've assumed in the total price calculation here does reflect that SPS's fuel costs are lower than they would have otherwise been in a historical time period, given the installation and operations of the Hale and Sagamore facilities. So this is not a projection of associated reductions in fuel costs, but representation of the fuel cost savings that we see on our system with those wind facilities online.
Right, and I'm just trying to get a clear view of what I'm looking at. And I want to make sure that when we that I know what we're looking at. And secondarily, I want to make sure that we're comparing similarly situated apples to the same similarly situated fruit. Okay. So I know in going back and having reviewed SPS's past 2, 3, 4 rate cases, and especially the last one, 20-00238, it sometimes is unclear when we're looking at numbers that are purely revenue increase numbers, and when we're looking at what might be some people might refer to as a complete revenue picture, because it will actually show any reductions that the customers might get that get passed through the fuel clause. Isn't that right?
Yes.
Okay. So if I wanted to just look at rate base increase numbers and customer class increases, and I don't want to see any associated effect that reductions through fuel might have, am I talking about the kind of comparison that you're referring to in your testimony on page 26?
You are, because again, the fuel and other revenue that's assumed in the presentation of overall revenue changes in this proceeding is not projecting a decrease in fuel costs associated with the wind production. And that's shown also on my attachment BAT step 1. You can see on line 2, the fuel and other revenue line in the associated footnote, that no adjustments to fuel and other revenue are being proposed as part of that case. So when we say test year revenue under current rates on the fuel and other revenue line, that's an actual number.
Okay, so going back to page 26, when you say at line 4, SPS's proposed bottom line rates to customers would be 37% below the national average and 18% below the New Mexico average, then we're just talking about rates that don't include any fuel savings, correct?
That's correct. And I would also clarify, it's a retail average price across all the customer classes. And I think your earlier question asked about, in particular classes, those customer class specific rates are shown in the proof of revenue statement. It's included in attachment or exhibit A to the stipulation, just for reference, Your Honor.
And your footnote says the stipulation would result in New Mexico retail average price across all customer classes, inclusive of fuel, is 8.07 cents per kWh. The national price is 12.81 cents per kWh. Now, is that national price that you reference in the footnote inclusive of fuel?
Yes.
Okay. And it says the New Mexico average is 9.82 cents per kWh. And then now we look at the screen and my request to you, I just wanted to know why you chose that particular February data, and you have updated this to have March data, correct?
We have. This information is sourced from the U.S. Energy Information Administration's data sets. There's lag on the compilation of those data sets. So at the time that we filed the testimony in support of the stipulation, February data was all that was available from the US EIA. At the time we prepared the bench request response, there was another month added to that data set. We thought it might be of interest to you to see a refreshed look at the calculation.
So then according to this, with one more month of data, the national average price decreased, correct?
Yes, from 1281 to 1249.
And the New Mexico average price also decreased, correct?
Yes, from 982 to 919.
Any explanation for that?
In terms of the changes from the EIA dataset, that's going to be a reflection of information submitted by other utilities and all utilities in the country. So I don't have any particular pinpoint that I can offer you for why that decreased.
Okay. Let's go on to the next bench request. And that had to do with page 25 of your STIP testimony.
I think this reference, Your Honor, was the rebuttal testimony.
Oh, it is. That's why I'm not finding it. SPS must purchase NOx, and that's spelled capital N, capital O, little x, allowances to economically dispatch its units to provide safe and reliable service at a just and reasonable rate. So I wanted to know whether or not SPS was proposing to collect NOx costs incurred for all generation units through the FPPCAC. And your answer is yes. And you refer me to page 90 of your stipulation testimony, correct?
Yes. I'm sorry, page 90 of my
No.
direct testimony.
Correct. Well, I don't know that that got me where I needed to go. So
Okay, I think if I may, Your Honor, the question's asking if is it only Tolk? Is it other units on the system? We do have other generation units that emit NOx. I don't have that list at top of my mind right now, but we could, I'm sure, get it for you if you're interested. But essentially, NOx allowance costs are incurred if production will exceed our allowance under Casper Group 2 program. Again, it's more than just the Tolk units that are subject to NOx regulations in our Texas service territory.
are there are there any other generation units in your Texas service territory that provide generation for New Mexico that incur NOx allowance costs?
Yes, all of our units provide service to New Mexico customers. We run our generation fleet as a system fleet.
Very well. Consider that, Ms. Hardy, bench request numbers 2. I would like a list of the other generation resources who incur NOx allowance costs. And I'd also like to know whether or not, Ms. Trammell, all of the NOx allowance costs are collected through the FPPCAC.
Understood, Your Honor. I would just offer today, no NOx allowance costs in New Mexico are recovered through the FPPCAC. That was our request on a going forward basis. In other words, after the effective data rates in this proceeding, we're asking to move recovery from base rates to the fuel clause. But that is a request pending in this proceeding.
And was that request addressed in the stipulation?
Yes, it was. The parties and the signatories agree that it is reasonable for SPS to recover NOx allowance expenses through the FPPCAC following the effective date of rates in this proceeding.
Do you know, I mean, is that how you collect them in your Texas jurisdiction?
Yes.
Do you know whether or not Excel's other subsidiaries collect them through a similar mechanism to a fuel clause?
It's my understanding that Public Service Company of Colorado is not subject to the CASPR program or to any NOx allowance trading programs. It's my understanding Northern States Power Wisconsin is subject to Group 2 cross-state air pollution rule. And therefore they do incur NOx allowance costs and they do recover theirs through the fuel clause. Northern States Power Minnesota recovers their costs, their NOx allowance costs through base rates currently, but will be asking the Minnesota Commission for authority to implement a deferral framework. That would be similar to what SPS has today in New Mexico, the deferral framework, except for SPS has an unreasonably low cap on that deferral, given the price that NOx allowances trade for today under CASPR regulations.
Speaking of Minnesota, the particular proposal that you're talking about, is that included in case number 21-630? That's currently pending before the Minnesota Public Utility Commission?
I don't think so.
Know.
I don't think they've made the request yet.
Okay. I spent some time on the Minnesota Public Utilities Commission website over the weekend, and which, by the way, they have a very nice site, easy to look up records, so compliments to them. But I noticed that this year, both gas and electric for Excel have had decisions before the Minnesota Commission, although I say decisions, the one for the electric rate case that I asked you about was just issued on June 1st and hasn't been memorialized in writing. Do you know if that's correct?
That's what I understand. I think the commission deliberated in early June, has not issued a written decision.
Okay, but for our purposes, you don't think that the proposal that you made in this case and then changed has been offered in Minnesota?
I'm sorry, what do you mean by changed?
Well, wasn't there a regulatory asset component to your original proposal?
Our proposal or a request in this proceeding is to move recovery from base rates to fuel.
Okay.
So in the alternative, if the commission's not inclined to authorize recovery through fuel, base rate recovery is still an option, of course, not as applicable in our opinion, but we would request that the cap be removed. The current cap is $110,000. The cap on that deferral is $110,000 total company. And in 2010, when that cap was established, that may have been reflective of the costs of allowances, but it is no longer reflected of the market prices we see. In other words, absent a change to that cap, we're essentially receiving a very significant disallowance of NOx allowance expenses under New Mexico rate making provisions.
Is that an additional incentive for the company?
I don't think so, Your Honor, because in order to not have the emissions, we have to not run the plants. Customers need the plants. they need the production, they need the generation to serve load.
Do you know whether or not that Public Service Company of New Mexico recovers any NOx allowances that they may be subject to through their FPPCAC?
I do not know, Your Honor. I know that our base rate recovery was established in a settlement in a prior SPS case. In that case, our initial recommendation or initial request was to recover the allowances through the fuel clause. Again, that was a settled case. So in conjunction with other items that were a part of that settlement, we agreed to the base rate recovery.
Okay. I know that that I tried to locate in case number 22-166, which is Public Service Company of New Mexico's FPPCAC, which got merged into 22-00270, which is their rate case. And I couldn't find it specifically, but
I suspect I could call them, Your Honor.
that's okay. Again, just trying to be trying to be consistent. I mean, I realize it's been agreed to in the stipulation, but and then it looks like in my note, it looks like SPS witness Nemi also discusses the FPPCAC in her testimony. Correct?
With regard to NOx allowances or other items?
Well, no, it just just with regard to fuel and purchase power expenses, I'm assuming that includes NOx, correct?
Yes, so she has a couple of recommendations related to that. On a basic level, items recovered through fuel are excluded from the revenue requirement calculation. So I suspect she has a general discussion of items that are removed from the base rate cost of service calculation because they are recovered through fuel. With respect to our NOx recovery proposals in this proceeding, again, because we were subject to the cap in calendar year 22 and calendar year 23, largely calendar year 23, given that the effective data rates in this proceeding are set to is set to be, I think, October, mid-October. We would have NOx expenses incurred above the cap. So she discussed also rate making proposals in this proceeding to recover those amounts in excess of the cap. However, in the stipulation, as you're well aware, we have agreed to not seek recovery of the NOx allowance expenses incurred in 2022 ozone season above the previously established cap, as well as to not recover any costs incurred in the 2023 ozone season above the cap.
And that actually, well, let me go ahead and hopefully I'll remember that. Okay, so you're answering in C how they're currently calculated. Then you talk about the case number 10-00395. That was a stipulated case?
Yes, Your Honor.
Okay. And then on D, you answer how the other jurisdictions. And then question E was, are there any other type of regulatory allowances or costs and that go through fuel? And the answer is no, correct?
To my knowledge, that's correct.
Okay. And then we went on to further on page 26 of your rebuttal testimony. You testified, oh yeah, you were referring to that Fifth Circuit Court of Appeals case. Next time when you refer to a case, Ms. Trammell, put that case side in.
Yes, Your Honor. Apologies for the oversight.
So basically then, I'm giving you the site and asking if that's what you're referring to. And I just needed a clarification in your testimony. Please explain how staying the rule in Texas equates or relates to your conclusion that it's reasonable for you to recover this through the FPPCAC. And your answer is, as a result of the stay, it's unclear whether or not you're going to have to purchase any. And recovering costs allows you basically to have a timely, I guess, and accurate recovery should you have to purchase some. Is that the gist of your answer?
Yes, Your Honor. For example, we could try to estimate costs that might be incurred, say, in ozone season 2024, if the stay was lifted or the litigation was resolved prior to May 1st of 2024. That's not our proposal in this case, and for our customers, we think it should be more accurate than that. The fuel clause will allow for that concurrent recovery, and I say concurrent from an intergenerational potential intergenerational equity issue. You know, a regulatory asset and base rates would be amortized off at some point in the future. So depending on changes in customer concentration, the recovery of those costs through base rates might be pretty far removed from the time period when the costs were actually incurred. So since the rule is stayed, that represents a pretty significant level of uncertainty for us in the future with regard to applicability of the Good Neighbor rule.
Well, how familiar are you with this particular process in the Fifth Circuit? And based on your level of familiarity, when do you think there might be a resolution?
No crystal ball there, but my understanding is the litigation could take quite a bit of time. We are anticipating that the stay would remain in effect throughout ozone season 2023, but the rule could be in effect in future years. So particularly in recognition that the future test year period in this proceeding ends June of 2024, base rate recovery, again, especially under the $110,000 total company cap, would likely not be reflective of the Good Neighbor rule or the Casper Group 2 NOx allowance costs that we incur. Well, so in other words, the fuel recovery of this cost for SPS is applicable whether Good Neighbor rule is in effect or not, in my opinion.
And hypothetically, Ms. Trammell, if the litigation and actual implementation or not of the rule occurred after, if the commission were to adopt your stipulation and allow talk to be abandoned in 2028, if some decision occurred after that period of time, do you know whether or not you'd have to go back and pay any NOx allowances that might have occurred during the pendency of the litigation?
My understanding is the rule will be stayed until the litigation is resolved. So if the litigation is resolved and the stay is lifted, the rule will either apply or not apply or be amended and apply. At that time, any compliance requirements for SPS under, say, an adopted rule or an amended and adopted rule would be on a going forward basis. It's not my understanding that there would be a retroactive application of a amended or adopted rule back to the published date of the finalized good neighbor rule. Again, that's my understanding.
Interesting. So actually might be cheaper to keep that litigation going until after Tolk closes than it would be to pay those NOx allowances. Maybe.
It depends on the outcome of the final rule. I know as drafted, the NOx allowance reductions under the trading program increase over time. In other words, if the good neighbor rule as published was implemented, SPS would increasingly see a decrease in their allocated allowances. So that would have an impact on the generation within the ozone season for our units subject to NOx regulations. That is essentially what I think we're getting to in question C and in our clarification with regard to Ms. Glick's analysis.
Right. I mean, do you disagree that there's that kind of cost discrepancy?
I disagree with how Ms. Glick modeled it, because if, again, just taking Tolk as an example, if higher NOx allowance costs are incurred or needed for Tolk generation, those costs will be reflected in the offer price for the unit. In other words, the offer price would increase to reflect those increased NOx allowance expenses. And it's my understanding that Ms. Glick's analysis did not assume that Tolk would be dispatched less as it received a higher offer price in the SPP integrated marketplace. So knowing that SPP economically dispatches all resources in the pool, the Southwest Power Pool, if Tolk costs are going up, it's going to fall in the stack.
And that was actually a question that I had on Ms. Lynch's cross-examination, and it relates to the section of the stipulation, which I know is worded very carefully, but it's worded so carefully that those of us who weren't privy to all your negotiations don't necessarily understand what it means. And I'm referring to section 17 on page 8 of the stipulation, which is entitled Tolk Self-Commitment.
Yes, I'm there. This is a different provision than the general dispatch offer prices that we submit into the SPP. I'm happy to elaborate on the differences.
Well,
if that would be helpful.
Yeah, but I want to start back to my understanding. You know, it says they agree to limit self-commitment, comma, as that term is defined by the SPP, comma. Well, I don't, and then of the Tolk generation units in the SPP's day ahead energy market to the following reasons. And then it lists things. Well, I don't have a SPP definition manual on my desk. So again, I'm sure it's worded very carefully to express the exact intent. But what it comes down to me, Ms. Trammell, that I wrote the question down, is it going to be SPP's choice to max the gigawatt hours on Tolk based upon an economic calculation? Or is it going to be SPS's choice?
It's a little bit both to set the offer price, but SPP is the entity that dispatches the units. So if we can compartmentalize those two things a little bit, it may help. So when we are looking to set an offer price, again, because we do have reduced operations at Tolk under the optimization plan, we have to work with the market monitor to set that offer price. So for example, we've set it in the past, recognizing water availability and the need to reduce operations of the unit. If we're needing to further reduce the generation output of the Tolk facilities due to applicability of good neighbor rule, for example, we would have to work with the market monitor to set that offer price. But once you're in the day ahead market and the offer prices have been submitted in advance of that operational day, SPP optimizes the dispatch of all resources in the Southwest Power Pool. So a number of factors can influence the ultimate dispatch in a real-time energy market. If there's a lot of renewable resources on the system, so if the sun's shining and the wind is blowing, et cetera, and those renewables are running, fossil units, even if they're low cost, would be further down in the stack. If load is low on the system, we might see a unit like Tolk be further down in the stack. If gas prices are low, we might see Tolk be further down in the stack. Conversely, if gas prices are high, the economic dispatch of Tolk would likely increase, as SPP would raise Tolk in the stack and call upon a unit like that ahead of higher priced gas units. Also, at night when there's no solar, or if the wind abruptly stops or fades off from a production standpoint, Tolk would raise in the dispatch stack as well. So those are just some examples of the dynamics of the real-time energy market dispatch by SPP. And to answer your question specifically, those dispatch orders are received from SPP by SPS. So SPS complies with the dispatch directives from SPP in the real-time market. That is different than how we work with the market monitor to set the offer price in the day ahead market.
Is SPS, does SPS have the ability through the use of the inputs with this collaboration with setting the price, have the ability to make the price higher or lower?
Yes, but to use a regulatory term, good cause would need to be shown, right, with the market monitor of what those prices need to be. In other words, can't just set an offer price. It would need to be reviewed here because the whole purpose of SPP's security constrained economic dispatch is to make sure that the most economical generation resources are being called upon first. And so if SPS is going to recommend a higher offer price for a Tolk unit, that offer price is going to be reviewed by the market monitor to make sure that SPS isn't withholding value from that energy resource in the day ahead market offer price submittal.
Okay.
So if they review the calculation, they understand the constraints of a unit, they will sign off on the market price and then it will be submitted.
So basically, would my understanding be correct then, as a member of SPP, you have made an agreement to provide generation pursuant to certain rules and pricing mechanisms?
Yes, that's fair. Those rules are included in the SPP open access transmission tariff. And to your earlier comment, Your Honor, a reference to that could have been useful on page 8 of the stipulation, because that is what, when we say the term defined by SPP, that dispatch definition is included, my understanding, in the SPP tariff or the SPP OAT.
OAT, right, okay. Well, I guess, I mean, I understand, and there's testimonies and one or two, I mean, you may have testified to it, I don't recall specifically, but at least in 2 witnesses' testimony for SPS, I remember seeing the alarming, and if we don't comply with SPS, we could be subject to fines of $1 million a day. And if SPS doesn't comply with the SPP requirements. So I guess if I come away with an understanding of trying to change from the current TOLC plan to a plan where TOLC is going to be used more. What I've heard from your testimony is if TOLC is going to be used more between now and 2028, how much it's used and when it's used is going to be determined by SPP. Is that correct?
Largely, and also the dynamics of the resources in the pool in the day-ahead market. But I just want to clarify a point. We're not proposing to run TOLC any more than we would have on a 2032 retirement date. It's just the time period is shortened, right? So from a gigawatt hour perspective, we're essentially running TOLC the same. We're just running or getting all those gigawatt hours by 2028 instead of by 2032.
So it's the difference between how long it's going to take me to drive the 60 miles to Albuquerque if I drive 75 miles an hour or I drive 25 miles an hour. I'm still going to get to the same place, but it's going to take longer or shorter, right?
I would agree with that analogy, roughly. You're still traveling 60 miles if that's the mileage you used in that example.
Okay, so then how does this section 17 self-commitment, how does that play into the analysis?
So there's, I believe, 5, call them categories of commitment under the SPP OAT. So
Okay.
what we've been talking about with regards to dispatch in the real-time market is what SPP refers to as market commitment. This provision is outside of market dispatch, labeled self-commitment. So for example, a utility operator may run a facility, may run a generation unit, even when it's not being dispatched in the market by the SPP. Examples of unit commitment can be the things that are listed in the stipulation, like testing, could be environmental testing or other things, right? An operator will have, say, monthly requirements to test units. Well, if the unit's not being dispatched in that particular month, we're unable to fulfill our reporting requirement on the testing, right? So we may have to turn on a unit to perform the needed testing. Another item is, reliability concerns. Sometimes we see a problem in the SPP, a reliability concern, before a dispatch order is received by SPS. So for example, if we're looking at a weather forecast or we're seeing characteristics of our load, particularly on units that have a longer startup time, we may want to self-commit a unit to get, say, the startup process started earlier, so that when SPP, say hypothetically, dispatches the unit or calls for the unit to be online in a, say, a hot summer day or a cold winter morning, we're not behind the dispatch because of the longer startup time. A safety item that comes to mind is the coal bunker. So as you can imagine, coal travels through a facility like Tolk. And so if the unit is dispatched down, so it's been running, but we receive a dispatch order from SPP to turn the unit off, we will do that. We'll comply with the dispatch order, but there may still be coal in particular places in the facility. So we may self-commit the unit to burn off remaining coal in the coal bunker or on the conveyor to remove the combustible safety risk that would be present in the plant with that coal sitting kind of waiting to be burned. So those are examples when a utility would self-commit a unit, and that's very different and distinct from market operations or market commitment.
Well, and since I'm looking at the STIP right now, and the section ahead of that is 16, and it refers to your IRP, and that's another question that I had on when you referenced the IRP in response to Ms. Lynch cross-examination. Did I hear you correctly? You have a current IRP pending with the commission?
Yes, Your Honor. Under the rule, we would have not filed our IRP until 2024. We petitioned to the commission to start our IRP process earlier. That petition or variance was granted, and our IRP, I believe, is case number 23-00073 UT.
Thank you. And since you were just talking about coal burning, I'll go to my third question that came from the cross-examination questions. I thought I heard you testify that coal contracts, if the stipulation gets approved, and that there would have to be negotiation of coal contracts after the commission approval of the stipulation. Was that correct?
We would need to negotiate extension of the coal supply agreement regardless of the commission's retirement date decision in this proceeding. Our currently effective coal supply agreement goes through December of 2027.
Yeah, I thought I saw 2027, but I was also wondering about your I don't know where my note went, but your Texas proceeding. You've requested also to change the retirement date in your pending rate case in Texas?
That's correct.
Okay. So then we can go on to number 1A. Hold on, let me get Mr. So in the bench request number 1-A, I'm referring to your stipulation testimony on pages 54 and 55. Good afternoon, Commissioner Aguilara. Welcome to our proceeding.
Good afternoon.
So I was just asking about how that retention of the 236th portion, and you have answered that question for me. So those are my questions to you on putative exhibit, commission exhibit 5. Your answers are true and correct, Ms. Trammell?
Yes, Your Honor, based on my knowledge.
Okay.
Was there a question I could assist you with regard to bench request number 1-1? I recall
Well,
a
I was
discussion
just,
there with.
yes, with Mr. Rodriguez. No, I was just happy with the update to Mr. Lau's DAL1 to tell me exactly what the source of the fuel was. And I believe I just compared them to Mr. Rodriguez attachment 3. Do you recall I had a question about them?
I think you had 2 questions. Who owned Blackhawk, and were there any differences between that table and the map? I think the only difference that I recall was potentially our Black Start unit is not shown on Mr. Rodriguez's map. And it's my understanding that Borger Energy Associates is the owner of the Blackhawk facility, which.
How do you spell that?
Borger, Borger.
Okay. Are they a Texas company or are they a multinational company?
I think they're owned by another company called Contour Global. So in terms of PPA counterparty, we would have a commercial relationship with Contour Global as well as Phillips 66. So I don't know the business registration of either of those legal entities, Your Honor.
Okay. And so that's the owner. So that's the answer to bench request 1. So we can mark that out now. And
Judge, this is the reporter. Can you spell oat?
Oat is capital O, capital T, capital T.
Your Honor, if I may, there's an A in there as well.
Oh, OATT.
That's correct. It stands for Open Access Transmission Tariff.
Thank you, ma'am.
All right, great. I'm calling mine an ought. All right. No, so very good. And I haven't heard any objection. Would parties like for me to go ahead and clarify the rest of this exhibit? Or are people willing to accept the Ms. Hardy, did I have a verification?
I believe there should be verifications, Madam Examiner. So I will need to check on those if they aren't included.
Okay. Sometimes when I download the exhibit for myself on the flash drive, I don't include all of it. So, okay. Well, I won't offer that one yet then. And in the spirit of trying to move our hearing along, Ms. Trammell, I just have a couple of other questions for you. Do you have any more clarity, Ms. Trammell, on or granular information? Since you have granular information, when SPS is likely to file its next rate case?
We don't have an exact date, but I would offer to you, Your Honor, and the commission that as we look at the items that have influenced the timing of our rate cases in the past and the timing of this case, as Mr. Rodriguez described earlier, the wholesale ramp downs, that schedule of our wholesale load departures has been a primary factor influencing the timing of our cases. So as was also discussed this morning, we are at near the end of those wholesale departures. The last of our wholesale production customers will depart the SPS system in 2026. So to your point, that's decreasing. That reason for filing rate cases is decreasing over time as we near the end of our ramp downs. So increasingly influencing our timing for cases is the ongoing capital investment needed to support our load growth, primarily load growth in Southeast and Eastern New Mexico, which is supporting many industries in the state, including the oil and gas industry, which supports, of course, the state's economy, but also increasingly our generation fleet transition. So it's partly the generation fleet transition is coming into play because we're at the end of those wholesale ramp downs, but also because we have additional load growth and unit retirements. So as wholesale ramp downs have occurred, that's freed up generation capacity for our retail customers. But if we're to the end of the ramp downs and our load is growing and our capacity position is changing due to unit retirements, we have now a more traditional resource need and the need to be evaluating resource transition topics. So you've seen those topics brought forward in this case with regard to addressing abandonment authorities for our retiring units in the near term, as well as associated regulatory proceedings from SPS in New Mexico, like our IRP and our request to start that IRP process a year earlier than we otherwise would have under the Commission's rules. So looking forward into the timing of our next rate case, if you think of those main drivers affecting our business, generation fleet transition costs will be potentially our primary driver, as well as continued distribution investment to support our load growth in New Mexico. We, on June 5th, awarded bids under the 2022 Request for Proposals, or RFP, that we issued in the fall as an update to our 2021 Integrated Resource Plan. Those units largely will come into service in 2026 and 27. So there's 3 solar facilities that were announced in that project selection, as well as extension of the Blackhawk PPA. And as well as Mr. Adrian Rodriguez described interest in adding batteries to our system. So if those resources are approved in the CCNs that SPS will be submitting later this year and are brought online in that 26-27 timeframe, those generation additions would represent a material need for a rate case in SPS's near medium-term future. So can I definitively say today that we won't file a rate case before we seek to include those new generation assets in base rates? No, I can't, because that'll be dependent again on our other investment levels, changes in costs in the company and our load growth. But I can certainly say we'll be looking to eventually bring those new generation resources into base rates close to, or if not concurrent with, their in-service dates.
Well, in that frame of mind, and while listening to your testimony, Ms. Trammell, in probably the past 4 minutes, I have lost the Zoom feed 3 times. So I don't know if you all are experiencing any problems, but I do have I put in a call to IT. So I don't know if you have seen me go off the screen and come back on or not, but at first I thought I hit something, I hit a key, but that's not the issue. So we'll keep going, but I'm just sort of wondering in the same vein as what you're looking at and projecting the future, just in looking, I mean, you have pretty much every 2 years, you're filing a base rate case, right? 15, 17, 19, 20, and 22. Right?
Yes, that's correct. Again, that followed the timing of the wholesale ramp downs as well as the inclusion of Hale and Sagamore on our system. So pretty clear drivers for the timing of the cases.
Well, what I'm wondering is, of those 5 rate cases in the past, 5, 6, 7, 8 years, 5 and 8 years, I know that at least 3, 2, maybe 4. There's only been 1 litigated rate case out of that, hasn't there?
I think that's right.
And some of those rate cases have been settled for significantly less than the revenue requirement increase that SPS has asked for, haven't they?
I don't have those settled numbers on the top of my mind, but Your Honor, yes, typically the settled results are less than the company's initial ask. I would also note most of SPS's cases historically have been historical test years. So that is a driver, increasing the frequency of our filed rate cases. The fact that we're kind of looking in the rear view mirror from a recovery standpoint. So that is a benefit of this stipulation and the agreement to utilize a future test year period to revise SPS's rates. The reduction in regulatory lag that occurs with the use of the future test year should help to reduce the frequency of SPS base rate case filings.
Well, see, and I sort of have an issue with that, Ms. Trammell. I mean, and I have several questions for Ms. Martin on that, because, I really think it does a disservice to reference regulatory lag and point the finger in the direction of regulatory agencies as being the cause or the blame for the world's evils. And I'm just wondering if SPS ever considered, rather than filing frequent stipulated rate cases, which now are, I mean, it's escalated.
Have we lost the judge? I'm going to go off the record.
It looks like we lost her.
It looks like we're having difficulty all the way around. Judge, you're on mute.
Went away again for a while. Again, the point being, rather than having frequent stipulated cases where sometimes you settle for half or less of what you have asked for, perhaps SPS might actually, stick in there for a litigated case and then potentially have fewer rate cases.
Your Honor, I would, as a point of clarification, those historical test years were historical test years requested by the company. So, by no means am I pointing the finger at a regulatory jurisdiction there, right? We proposed HTYs in many of those cases. That's a reflection of our perspective on how future test years would be received from interveners and our ability to process that. A litigated case usually does mean more rate case expenses. And we also have understanding from a policy perspective that the commission favors settled outcomes, but your point is understood that use of a future test year proposal from the company could reduce the timing, reduce the frequency of rate case filings. And if we have key issues to address, perhaps litigation is the best way to resolve any disputes on those key issues. However, from the company's perspective, we do want to work with parties and interveners and see support for our changes in rates, particularly as we have pretty material changes to our customer concentration and business that is driving the need for our rate revisions. So I understand your point. We do default to wanting to seek negotiated and settled outcomes. We think that is favorably viewed from a number of perspectives, both customers, the commission, rating agencies, and the commission itself.
And
Mr. Lee, I've lost the question on my side.
I've lost the judge.
And I'm not trying to discourage any type of settlement or agreement, Ms. Trammell. Historically, the commission has had has encouraged those types of agreements. All I'm saying is when you look at it really looks like a pattern is developed in that has led potentially to increased costs. If you just isolate rate case costs, they used to be $1 million, $1.5 million. I think
We've lost the judge.
I apologize. I don't know what's going on. I want to call why don't we call a 15-minute recess? I'm going to try to get this IT problem straightened out, and we'll come back.
I would say we come back in 15 minutes.
Okay. For all of you out there that have your ears on, Mr. Chair, are you in the building? Somebody let me know that you can hear me.
I can hear you, Madam Hearing
Okay.
Examiner.
Great. Okay, John, so you're on there now. Commissioner, Mr. Chair, are you in the building?
Yes, I am.
Okay. If you look out your door, you should see Phil coming up there. You may need to access the Zoom through your phone hotspot. Temporarily, I've been told this is not an internal problem, it's a do it problem. And so I have been switched to the phone hotspot. So I'm trying to identify, I know Mr. Pagacco and Commissioner Aguilara are in the building. And so if you're in the building and you go in and out, find Phil.
Thank you.
Okay, thank you. I apologize for the technical difficulties. And I think we've got 2 minutes more. Good to know. Before we come back from our technical recess. Okay, let's come back from our recess. Come back from our recess and hopefully famous last words. Hopefully our technical gremlins have gone ahead and left the building. Okay, so again, I think Ms. Trammell, I'm just, just trying to find out if it might be less effort and, for strategy purposes, to have one rate case in a less period of time. I mean, maybe you might save on some rate case expenses and so just putting that out there again, not trying to discourage settlement in any way. But I think you understand where I'm coming from. I did want to ask a question, 2 questions that relate to the stipulation itself. Number one, and I didn't recall seeing it, but did the stipulation include any language with reference to SPS being in compliance with all the past case requirements that you included in your direct testimony attachment?
No, Your Honor, the stipulation document itself does not address that compliance. The compliance is demonstrated through my direct testimony attachment, and there were no parties that raised issue with those compliance items. But from an evidentiary perspective, to your point, the stipulation does not memorialize that. However, I think the record in this proceeding does.
And that would be my question to you. Is it your belief, Ms. Trammell, as evidenced by your direct testimony, including the attachment, that SPS has in fact complied with all of the commission prior case requirements as you set forth in your BAT 3, 28 pages worth?
Yes, based on my understanding and our compliance tracking and research, I would note there has been a couple commission decisions issued since I prepared that attachment and filed it in November of 2022. So notwithstanding any additional commitments that are now in play for SPS, yes, Your Honor, I think we're demonstrating compliance as reflected in that attachment.
In your testimony, you testified in response, I think it was in your rebuttal testimony, you testified in response to some criticisms about tracking numbers that SPS would or does a capital true up. Do you recall that testimony?
I do recall the discussion of a capital true up in my, I'll call it regular rebuttal testimony in this case, in response to parties' testimony and recommendations over future test year forecast uncertainty. I just want to make sure that's the testimony you're referring to. I don't have a page reference right now, but I can flip through my rebuttal to find it.
And I don't either, unfortunately. I just have a note. I have a Post-it note on your direct testimony. And before I lost that Post-it note, I wanted to ask you that because I'm wondering whether or not there's, that's actually going to be the procedure, even though I didn't see it elaborated in the stipulation.
No, Your Honor, the stipulation did not include a provision for a capital true up as I discussed in my rebuttal. So the stipulation accepts the future test year capital additions as forecasted by the company in the future test year period.
Okay. Also, with regard to the stipulation, is there any other request that SPS made in its case in chief that was not included in the stipulation that SPS expects the commission to rule on?
Yes, Your Honor. So largely the starting place for the stipulation was the company's rebuttal testimony. Now, obviously, we can't talk about offers and the negotiation process, but an example of an item that is not articulated in the stipulation, but was in SPS's request, and the request is reflected in the resulting rates from the stipulation, is SPS's proposed revised line loss study. So while the acceptance of SPS's revised line loss factors is not something that's noted in the stipulation. It is an underlying component of the rates established in the rate design, the stipulation rate design, and of course would need to be utilized from a fuel reporting and other calculations standpoint on a going forward basis until SPS's line loss factors are revised in a future proceeding.
Are you
Yes,
saying
that's-
line loss, LINE loss?
Yes, Mr. Lee.
Thank you, ma'am. Go ahead, please.
Thank you, sir. Okay, so far I've got a finding on compliance with past cases, and you want approval of your line loss study, correct?
Yes.
Anything else?
With regard to the Lubbock credit mechanism, we do need an authorization from the commission from an accounting standpoint to authorize a regulatory asset or liability there. That item's not specifically requested in the stipulation, but would be needed in order to effectuate the stipulation and commission's approval of those provisions. I can continue to think through that. I apologize, I don't have a good list of that on the top of my head right now, Your Honor, but for the clarity of your purposes and ours, as well as the interests of the stipulating parties and all parties in this proceeding, SPS is not opposed to preparing a list for you if you would like to issue a bench request.
Oh, yeah, like, consider it issued, SPS bench request 3. I would like a list of the authorizations that SPS is still requesting or is requesting either still from its base case or as a result of the stipulation that are not enumerated in the stipulation.
Understood,
Okay.
Your Honor.
Is that clear, Ms. Hardy?
Yes, Madam Examiner, it is. Thank you.
Okay, thank you. And Ms. Hardy, what was the list that I wanted in bench request 2?
Bench request 2 was a list of all units that incur NOx allowance costs.
Ah. That's the problem. When you're saying it, you're not writing it.
I understand.
Okay, so, all right, so those were two big ticket items. I've already asked you about the FPPCAC. With regard to the findings necessary for abandonment or as requested for Plant X units 1 and 2 and Cunningham unit 1. When you ask for the abandonment of those units, and I'm referring to starting at page 49 of your direct testimony. Is it SPS's intent that that is actually when everything gets turned off and the plant no longer operates at all? when you ask for that abandonment timeframe?
Not necessarily. Abandonment is more of a departure from the unit. So when you say turned off, I mean, if you mean turned off and not used again, then yes, technically we'd be abandoning this facility from utility operations. But it's my understanding that the Abandonment Authority in New Mexico requires that finding. So before we do officially retire a unit, we need the abandonment approval from New Mexico.
Well, it it just seems like there's a pattern and practice with these units. At least what I see is like almost every rate case, you're coming in and said, yeah, we want to abandon this plant by X date. And then a few years later, the next time it's like, oh yeah, well, we want to change that date and we want to do something else. We want to put, these synchronous condensers on it and we want to use it for voltage support. Or in the case here, we want to shorten the date. So I start to get the feeling that when you're asking for abandonment, it's sort of like this ethereal concept that you're never, you're not really going to ever turn the plant off. It's just going to morph into something else. Is that not correct?
I would disagree. I think we've had a more complicated situation with Tolk. I'm not aware of any other revised abandonment dates that the company has sought for units other than Tolk. For example, I think in the last SPS rate case, we were seeking abandonment authority for Plant X3, which was retired and abandoned as a conclusion of that proceeding. We have not previously, to my knowledge, sought abandonment authority or received an abandonment finding from the commission related to Plant X1, X2, and Cunningham 1. We do intend to retire those units in 2023. Those are the retirement dates from a depreciation standpoint included in our request as well as in the stipulation. So because we're increasingly getting closer to our retirement dates, the commission is seeing more abandonment authorities requested by the company, right? When we weren't as close to retirement dates, the abandonment authorities perhaps weren't being addressed in SPS rate cases. For example, with the Nichols extensions that we've sought in this proceeding, the retirement date is now, assuming the commission approves the extension, farther down the road. And we're not seeking that abandonment authority here, but believe it to be more reasonable to request the abandonment authority closer to the retirement dates. So I think the relationship that you are observing is a function of the proximity in time to our retirement dates, particularly of our fossil units.
Okay. I thought we had done unit 1 and 2 before, but
If I recall, there was a proceeding that was withdrawn.
okay. All right, Ms. Trammell, I believe that hits the high points.
Well, thank you, Your Honor, and thank you for the detailed review of my many pieces of testimony in this proceeding.
Your Honor, I do have some follow-up questions to yours.
Well, you have to wait your turn, Ms. Lynch.
Okay, thank you.
I'll give this opportunity if the commissioners have any questions based on my questions. Not hearing that the commissioners have questions.
Hearing examiner. I do have just a few questions.
Yes, sir. Commissioner Aguilara. Go ahead, sir.
Hi, Ms. Trammell. Thanks for being here and for your testimonies. I do have a few questions, just trying to understand a little better how the toll generator is dispatched in SPP. From a recent, I guess, historical point, how often is it dispatched? And I'm wondering if the dispatch has been changing at all, and specifically whether it has been dispatched less and less with the addition of more renewables in SPP's footprint.
Yeah, great question, Commissioner. We do see variation in the dispatch of the Tolk units as well as dispatch of other gas units on our system, and as well as Harrington, largely in response to renewable penetration and renewable availability on the system. The dispatch of our fossil units are also primarily influenced by gas prices. So clearly, when gas prices are higher, the gas units are going to change location in the stack, and the coal units will be dispatched more. So for example, in 2022, when we saw significantly higher gas prices relative to calendar year 21, we saw the coal units dispatched more. On a low load day, in the spring, kind of that March, April timeframe, we may see lower dispatch of those resources, but that's a reflection of low load. At night, we would see, more dispatch generation from our fossil fleet if renewables are low on the system, or during the day if wind cuts out dramatically, or even if it phases into a lower output, we'll see dispatch. Overall, since 2014, when SPP implemented or commenced the operations of the integrated marketplace, we have seen more starts on our systems, on our units. So, we are following the integration of renewables over time from our dispatch stack. From an energy standpoint, the renewables will always be dispatched first. So long as they're there and producing, other dispatch of other units will be affected accordingly. To give you, particular days, I don't have that information. I know lots of folks in our company follow it. Our commercial operations team obviously manages the dispatch of the units throughout the day, but generally at a high level, I think that characterization offers you some of the diversity we see in our fleet dispatch.
Okay, thank you for that. So it seems like there are various factors sort of driving this, with renewables being online, then maybe it's not dispatched, but when you have high natural gas prices for your fuel, then the coal plant might be dispatched more. And then so I understand maybe there's not like a clear answer here, but I'm wondering if there is a trend, and whether that trend is, the toll generating plant is dispatched about the same, if you were to draw sort of a trend line on that, or if it's being dispatched less and less.
I would lean towards more. So just to give you 2 examples, in calendar year 21 and 22, these are a little event specific, but for example, during Winter Storm Uri, the units were absolutely needed from a reliability dispatch perspective. So we saw more generation from those units in that event than would have otherwise probably occurred if that event had not been on our system. That's an isolated example that spanned, several days, not an entire year. But again, the 22 example of elevated gas prices definitely calls upon Tolk unit dispatch more so than historical years when gas prices were low. And that is material to some of the considerations the commission will be evaluating in this proceeding, because our previous Tolk analysis, the Tolk analysis that was provided in our 2021 rate case, largely looked at a gas price environment that was reflective of those lower prices and materially different than the gas prices we saw in 22 or forecasted in the near term in the updated Tolk analyses.
Okay, thank you. And then, so does Tolk have any kind of a must offer obligation in SPP?
It could. I think all units could, depending on the stability of the transmission system. Usually transmission operations dictates a unit's must run status. So I don't know for sure, Commissioner, if it does in a particular point in time. I am familiar with other utility systems where, based on the configuration of the system, a must run typically is pretty prevalent. I'm not aware of that relationship with the Tolk units, but that's not to say that it may not be designated as a must run unit if transmission operation calls for that kind of grid stability.
Okay, thank you. And so I'm more familiar with CAISO's market than I am with SPP. So one question I have is whether in SPP's market you can reflect regulatory limitations into the dispatch, like in a master file, and then separately whether contractual limitations would also be respected in the market, such as something that would come out of this rate case.
Generally, I think the answer is yes. Again, that's a conversation with the market monitor. Jared Cooley may be better to answer that question in more detail with regard to those processes, or potentially Mr. Elsey. But given your term respected, yes, I do think those considerations are taken into account. Again, there's many factors at play with regard to management decisions for the dispatch of a unit. And I think many factors at play regarding the commission's evaluation of the reasonableness of the stipulation here on the Tolk retirement date and the projected gigawatt hour targets that we've shared with the commission would be our intention for operations through the end of the unit's life. For example, this is a rate case, right? There's also a statutory requirement in a rate case to set just and reasonable rates, and lower production from the unit, particularly in a higher gas price environment, would reduce the economic benefit to customers.
Okay, thank you. And then I have one final question with respect to recovering the NOx allowance cost in the FPP CAC. And I recognize that the hearing examiner already asked if you knew whether PNM recovered them, or how PNM recovered any such costs. But I'm wondering if there is any larger sort of precedent or policy. I mean, I do sort of see your point, how you think that these allowance costs would be more appropriately recovered through sort of your variable cost recovery mechanism. But did you perform any kind of research as to how other companies that even across the country recover those costs?
I think the best point I can share with you regarding the reasonableness of fuel recovery of these types of costs is actually in relation to our purchase power resources. So we do have dispatchable PPAs, and if say a gas unit that we contract under a PPA is also subject to CSPR regulations, they would also have NOx allowance expenses incorporated into their PPA prices. Even outside of PPAs, if we make market purchases in SPP for other dispatchable units in the pool. Again, if they are subject to the CASPER regulations, because that's the existing regulations today, those NOx allowance expenses would be reflected in their offer price into the SPP integrated marketplace as well. So as we make a market purchase, we're paying a market price and recovering that market price through the fuel clause. That market price includes NOx allowances. So it's inconsistent to recover the same kind of expense just based on who's incurring the cost, a company-owned generator versus a market purchase generator. So that to me is a good example that just highlights from a regulatory rate making perspective, the disconnect with the current SPS NOx recovery parameters in New Mexico.
Okay, thank you, Ms. Trammell and hearing examiner. Those were the questions I had. Thank you.
Thank you, Commissioner.
Thank you. Thank you, Commissioner Aguilara. Anything further from commissioners?
Yeah, actually, this is Commissioner O'Connell. I did have a follow-up on question Commissioner Aguilera just asked, but
Go ahead, sir.
briefly, I was listening to the relationship between Tolk generation and natural gas prices, and I've looked at what I think is annual net generation from Tolk and not seeing that relationship showing up in the data. So really, rather than a question, it's kind of a request that for a witness to come in this hearing, if somebody could be prepared to provide the net generation at Tolk for the last 5 or 6 years with what the gas prices were. Because I mean, there is, looks like 2022 was higher than 2021, but not to the dramatic level I expected based on the narrative.
I understand the question, Chairman. We can make that information available through either SPS witness David Lau or potentially through Mr. Elsey. I think what Mr. Lau may also be able to provide is information related to the frequency and number of starts. So even if the generation isn't materially increasing from year to year, the activity of the plant, if you will, is materially different under different gas price environments. That
Does
has
number of starts affect amount of NOx emissions?
I'll defer that to Mr. Lau based on the characteristics of the ramp up time and how that emissions profile changes as you operate the unit in warm start or hot start. But he can speak to those technical differences. It may.
Yeah, it'd be real helpful to get some actual data to put this in context, because like I say, what I'm hearing versus what I'm seeing, and I'm not sure I've got the right numbers. There seems to be a gap.
Understood.
Ms. Hardy? Do you understand the instruction for SPS witness Elsey and or Lau?
I do, Madam Examiner. My understanding is that we've been asked to provide the net generation at Tolk for the last approximately 5 years and discuss how that is impacted by the gas prices. Is that correct?
Commissioner, Mr. Chair, is that what you want?
Yeah, that's correct, with the grace note of apparently number of starts matters too. So in the context of these amount of money that has to be spent on NOx, any information they choose to supplement to tie starts to NOx costs would be helpful too.
And Mr. Chairman, that is potentially also influenced, of course, by the ozone season not being the full calendar year. So those starts within the ozone season, but we will try to put that information together. Thank you, Your Honor.
Very well. Anything further, Mr. Chair?
I haven't been keeping track, Madam Hearing Examiner, but sounded like early on Ms. Trammell did a great job of deferring to other witnesses. So per your rules, she must have a large paycheck for not working for free this month.
Okay, open that pocketbook, I guess. Very well.
I have I have just a few questions, Examiner Hurst.
Yes, sir. Go ahead, Commissioner Ellison.
Sure. Thank you, Ms. Trammell, for appearing today. Could you tell me where Plant X is physically located?
I think you mentioned earlier that you're familiar with Muleshoe and the location of Tolk.
Yes.
Plant X as a complex is located, I think, just east, maybe a little bit southeast of the Tolk facility. So it's in the vicinity of Tolk. They're in around Earth and Muleshoe area of Texas.
Okay, thank you. I just didn't see it on the map that Mr. Rodriguez showed us. I have understood that historically your jurisdictional split has been about 60% Texas, 40% New Mexico. Has that changed now?
No, sir, that's very close to our jurisdictional split on a production basis. So just to use numbers from this proceeding, Texas production allocation in the FTY period is about 58%, so pretty close to your 60 that you had in mind, and New Mexico is roughly 38%, again, pretty close to the 40 that you articulated. Those numbers are different from a transmission perspective. New Mexico has a higher allocation, a lower allocation of the transmission load, I believe, closer to maybe 29 or 30%. Texas being closer to 44%, again on a transmission basis. And that's a reflection that those wholesale customers that have departed our system as production customers remain as transmission customers. So they still take transmission service across our network, and therefore the wholesale allocation on a transmission basis is higher, of course, than on production basis. So around 44 Texas, 29 New Mexico, again, from a transmission standpoint.
I see. Thank you. And have those changed as a result of some of the wholesale power changes that you've experienced?
They have. They also change as a result of load growth among the retail jurisdictions. So to take those one at a time, certainly the production component is materially impacted by the wholesale ramp downs. So the wholesale portion of our production system is declining. The load growth in the two retail jurisdictions, or the relationship between the load growth in the two retail jurisdictions, does impact the allocation. To put it simply, what we've seen is more load growth in New Mexico than Texas. Both states are growing, but New Mexico is growing at a faster clip, and therefore it is pulling some of the allocation to New Mexico. With that, pulls also additional revenue. So from a future test year perspective, as we incorporate higher load into our billing determinants and reflect that higher load in our jurisdictional allocations, we also reflect an increase in present revenue for the FTY period, as well as an increase in the allocation of production tax credits that are allocated on an energy basis to New Mexico versus Texas. So there's a lot of relationships there that influence jurisdictional allocations, as well as other allocations between our retail jurisdictions as our wholesale load departs.
Okay, and are those changes between the, I guess the jurisdictional split, is that, would you say, the primary driver behind this rate case that you filed?
Yes, that is one of the three primary reasons that I articulated in my testimony for why we filed this case: the wholesale departures, the investment levels to keep up with the load growth, particularly in New Mexico and Southeast New Mexico on the distribution system, as well as the generation fleet transition matters that we needed to address in this rate case.
Okay, thank you. And the NOx regulations, could you explain in a nutshell how that works in Texas? Is there an annual cap as to how much NOx your plants in Texas are able to emit?
I think effectively the allocation of the NOx allowances serves as a bit of a cap. If you're out of allowances, there is a market for allowances. So if there's market allowances available to be purchased, it's my understanding an operator can purchase those allowances and generate more than their allocated allowances would have provided for. But if there are no allowances available, then the allocation under the Group 2 allocation today would serve as a cap. Not sure if that qualifies as a nutshell, Commissioner, but that's my best.
That's pretty close. And do those NOx caps apply to your plants that are physically located in New Mexico?
No, it's my understanding the CASPER regulations apply to facilities located in Texas.
I see. The cost of purchasing additional NOx allowances, is that something that is considered when SPP dispatches the Texas plants?
Yes, because those additional costs would be built into the offer prices.
Okay. One last thing, and I'm not sure if your testimony covered this, the wind production tax credits and the potential that's opening up now to sell those credits. Is that something I would be better off asking witness Martin about?
I can address some questions on that probably, but also our tax expert is Naomi Koch in this proceeding. So the PTC transferability provisions are in effect with the passage of the Inflation Reduction Act for production starting in 2023. So we do have the ability to essentially sell unused PTCs that we generate in calendar year 23. There's, oh, go ahead.
I'm sorry. Assuming you're able to sell those as you anticipate, to whom would the benefits of those sales accrue?
Effectively, selling the PTCs has the effect of reducing the balance of the deferred tax asset associated with the PTCs. So currently in base rates, there's what we call a DTA, a PTC DTA. So that's a deferred tax asset that accumulates as SBS is unable to use tax credits on its tax statements with the IRS, right? So if we don't have a tax liability, we're not able to utilize the credit that creates the PTC DTA. The relationship of the PTC transferability has an ongoing benefit to the balance of the DTA. So in other words, if you're selling PTCs as opposed to not using PTCs, the balance of the DTA will not grow. With the transaction to sell the PTC credits comes a transaction cost. So from a rate making perspective, we would incur an additional cost to effectuate the sale of the PTCs, but then also have the customer benefit of reducing the DTA balance. For SPS and the application of PTC transferability for Hale and Sagamore, which are the two units currently on the system for which PTC transferability would be relevant starting in 2023. There are certain provisions in the CCN stipulations that were entered into for those facilities that come into play, and there are restrictions on the DTA recovery. So from a customer benefit and analysis perspective, Commissioner, I would just offer that what I've described is fundamentally the concept, but it is impacted by the specific provisions and regulatory approvals of DTA recovery for SPS in those wind settlements.
Great, thank you. One other thing, the Lubbock Power and Light sale, what I guess percentage of those proceeds would you propose should be allocated to New Mexico customers?
If I may, Your Honor, refer to the response to our bench request. I think it was Commission Exhibit 5. I believe we provided a demonstrative calculation of the New Mexico retail portion of that exit fee payment.
You did.
Approximately 28.3 million in total on a New Mexico retail basis. So that includes the recognition of the split between production and transmission of the exit fee payment as agreed to by Lubbock and SPS in the LP&L SPS settlement agreement.
Okay, thank you, Ms. Trammell. That's all the questions I have for now.
Thank you, Commissioner.
Thank you, Commissioner. Ms. Hardy, do you have any redirect for your witness?
Madam Examiner, I believe I only have one or two quick questions.
Okay, go ahead.
Thank you. Ms. Trammell, earlier when you were questioned by Ms. Lynch, she asked a number of questions about using all of the remaining economically available water at Toke by 2028. Do you recall those questions?
I do.
Does SPS intend to use all of the economically available water at Toke by 2028?
No, we do not. Ms. Lynch was asking me a series of questions that I interpreted to be definitely centered around the modeling. But from an operational standpoint, I think the best example that I can illustrate that it is not SPS's intention to deplete the available water in the Tolk well field is the simple fact that water will still be needed for synchronous condenser operations at the Tolk facility. The expected asset life for the synchronous condensers is through 2055. So we will still need water acquired through the Tolk well field to cool components of that facility into mid 2050s for synchronous condenser operations. Now, granted, the amount of water needed to cool components for synchronous condenser operations is significantly less than generation, but it's just a reflection that we are not intending to deplete the well field.
Thank you. That was my only question.
Oh, did you happen to see, are you familiar with P&M facilities in the Four Corners area and the shutdown of that coal-related facility?
I'm familiar with Four Corners. I'm not familiar with its retirement or closure specifics.
Well, it seems like I saw in the news recently that they were giving their whatever water plant facilities that they used, I think I don't know if I believe it was the local community. Did you see anything about that?
No, Your Honor, I'm not familiar with that.
Okay, so basically we're probably not going to see SPS be giving any of its water related facilities away if Tolk is abandoned in 2028.
No, again, I would expect the facilities to continue to need to be utilized for SPS operations.
Has SPS asked in the past for asynchronous condensers?
I'm sorry, Your Honor, did you say A or 8?
A. Is there such a thing as an asynchronous condenser?
We currently can operate both of the Tolk units in synchronous condenser mode. So I'll leave the engineering to Mr. Lau, but I understand there's two. And yes, we sought approval to add the synchronous condensers in a prior case. I don't recall the case, but it was in, I think, the 2018-2019 timeframe. That was about the time we installed those facilities.
Okay. So he would be the one to ask why you would install one type of condenser in one facility and another type in a different facility.
Yes, I think he could answer that, but I don't think we have different synchronous condensers in TOLC 1 versus TOLC 2. But Jared Cooley can also address synchronous condenser needs because it is largely a grid stability tool as opposed to a generation asset. But both Mr. Lau and Mr. Cooley are familiar with its operations.
Okay, because I thought a lot of it too was voltage stability.
Yes, Your Honor, that's what I mean by transmission grid stability, maintaining voltage in the area, especially as our load pockets are, again, more at the southern portion of our service territory.
Okay, thank you. Ms. Lynch, I believe that you had some questions based on my questions.
You're correct, hearing examiner.
Okay, go ahead.
Okay, so I just have a few questions following up on hearing examiner Hurst's examination of you, Ms. Trammell.
Okay.
The first set of questions refers back to that analogy you were using of driving a car under the two scenarios of 2028 early retirement or 2032 at the current operation schedule. So the question I have is, would you agree that from a gigawatt perspective, operating TOLC at 2,400 gigawatt hours per year through 2032 and at 4,000 gigawatt hours per year through 2028 represents the same gigawatt hours over those two timeframes? Correct?
I think my car analogy was in response to test year convention. But again, these are annual production targets, and they have been modeled in Encompass based on the specifics of the operational parameters of the facility under those two retirement dates. Yes.
Okay. So, but this is not true from a NOx or a GHG emissions perspective, true? The NOx would increase under these two scenarios, particularly if you're using the plant at 4,000 gigawatt hours per year.
I mean, hypothetically, in a particular year, the emissions might be higher from both a NOx perspective and a greenhouse gas emissions perspective based on the higher levels of production. But again, over time, and I think that's the root of some of CCA's position in this case is the earlier emissions. But over time, I think they're pretty similar.
Okay, so NOx pollution will increase over the short term, correct?
Assuming that the units are dispatched at that level, yes.
And you agreed that SPS plans to dispatch at 4,000 gigawatt hours?
We plan to submit offer prices targeted at that. Dispatch is directed by the SPP.
Okay. And would that be true then for greenhouse gas emissions, meaning the greenhouse gas emissions will increase over a shorter term as well?
Yes, hypothetically based on a 2028 retirement date, there is an earlier emissions profile for this operational plan. However, there's also earlier economic benefits for customers, particularly in a higher gas price environment. And we've presented this information in the modeling in full transparency of our operational plans under this retirement scenario.
So would you agree that greater concentration of pollutants is worse for air quality?
Again, I'm not a environmental expert or a science expert. That may be better addressed by someone else. I'm not familiar with the exact specifics of what the emissions would be from different units on SPS's system.
and greater concentration of pollutants is worse for human health. Correct?
Madam Examiner, I'm going to object to these questions as being far beyond the scope of Ms. Trammell's testimony in this case.
Ms. Lynch?
I disagree that these questions directly relate to the examination of the NOx pollutants as a result of operating TOLC at higher capacity or at at 4,000 gigawatt hours per year.
I think they may have been testified, Ms. Lynch, by your witness, but I don't recall seeing that type of testimony from Ms. Trammell. So I'm going to sustain the objection. Do you have more questions?
Yes, I do.
Go ahead.
We'll move on to the good neighbor rule, which was explored by hearing examiner Hurst. So regardless of the outcome of the legal status of the good neighbor rule in the Texas case, increasing TOLC generation will increase NOx costs, right?
Depends. It depends on if our generation occurs within the ozone season and our generation in the ozone season exceeds our NOx allowances.
Okay. Regarding NOx emissions, has SBS been penalized within the last 5 years for not complying with requirements for those NOx emissions?
Not to my knowledge. I understand we've complied.
That's great. And then, okay, that concludes follow-up questions regarding those that you looked at, hearing examiner.
Okay. Thank you, Ms. Lynch. I believe that's all the questions, Ms. Trammell.
Excuse me, Madam Hearing
Oh,
Examiner.
I'm sorry.
Yes.
Mr. Smith, did you have some follow-up questions based on the commissioner or my questions?
I did have just a few clarifications if I could.
Yes, sir. Please go ahead.
First off, I wanted to clarify that the hearing examiner's bench requests are admitted into the record. I thought I heard you identify this as an exhibit, but I'm not sure I heard whether you admitted it.
Well, no, I was calling it a putative exhibit for so far, or a potential exhibit, subject to Ms. Hardy finding the verification from the witnesses. I was about ready to admit it, but it, since it's a potential exhibit, unless I hear an objection, you can go ahead and ask about Exhibit 5. Commission, potential Exhibit 5.
Okay. Thank you, Your Honor. Ms. Trammell, I just wanted to clarify a couple things here. First, with respect to nitrogen oxide credits, NOx credits, it is true that regardless of the good neighbor rule, the company will continue to incur NOx costs as a result of what's called the cross-state air pollution rule. Isn't that right?
We do anticipate to, again, because we're subject to those Group 2 allowances. But again, our actual expense incurred would depend on if we need to exceed our allocated allowance.
Right. Just wanted to clarify that they're technically two separate programs and one will continue to exist regardless of the other.
Agreed.
It's
It's my understanding that if good neighbor rule is ultimately enacted, that would be what we'd refer to as Group 3 emissions, and it would replace the Group 2 requirements that we have today. But in the absence of that rule being enacted, we're still subject to Group 2 under cross-state.
Thank you. And I think it might be helpful to just clarify a lot of the discussion that's gone into what is what you've referred to as generating or developing your offer prices at TOLC and how the units are dispatched, just to kind of tie it all
Sure.
together, I'm hoping. And so at the outset, I think you had mentioned to hearing examiner Hurst that there are 5 different commitment statuses that a generator can commit into the market under. And I believe, I'm not sure we identified all of them, but I want to just go through them one by one very quickly. Is it?
Sure, and I think I stated earlier that they may have been outlined in the SPP OAT. They might be in the market protocols. I may have incorrectly stated OAT before, but we can confirm that and clarify the record, Your Honor.
Would you accept that the 5 different categories are essentially market commitment, self-commitment, reliability, it's called testing, and then non-participation?
Yes, I think those are the 5.
Okay. And so I want to kind of just talk a little bit about this provision in the stipulation, that's section 17, and how that may work out in practice with the continued operation of the units. And so is it your understanding that this provision, section 17, the self-commitment language, essentially the company, subject to the limitations in the paragraph, is committing to bid the units, the Tolk units, into the SPP market on what's called market commitment, as we discussed?
Correct.
And you discussed a couple times, I think, with Commissioner Ellison and the hearing examiner, what's called setting the offer price or building into costs into the offer price. The offer price for the Tolk units is essentially their variable costs. Is that correct?
Yes, that's correct. And it's submitted in the day ahead market. So SPP receives those offer prices and plans the day, if you will, as it plans its dispatch.
Right. And each day the company, I mean, it can happen maybe more frequently, but each day the company puts together its day ahead market offer. Is that right?
That's correct.
And those variable costs, they include costs like fuel. Is that right?
Yes.
And as you said, they'll include NOx costs and the nitrogen oxide costs.
If applicable, yes.
If applicable. And other variable costs, would that be like operations and maintenance typically?
Yes, perhaps chemicals or other consumables. But yes, there's a multitude of factors that go into the offer price.
Okay. And so SPP then will take SPS's market offer and determine how best to serve all of the load at a particular time that needs to be served. Is that right?
Yes, through the dispatch. However, there's still the market monitor review there of the offer prices.
And the market monitor reviews it to make sure that it's an accurate representation of the variable costs of operating the unit. Is that generally correct?
Generally, or also reflective of the constraints that a particular generator may be facing.
Okay. And so given that market offer that SPS is making for its units, the market monitor or SPP then determines the total generation from all the different sources that have bid into the market. Is that correct?
Yes.
And so the actual generation profile at any given hour will depend on a number of different factors, right?
Absolutely. In the real-time market, which may be very different than what people expected to happen a day earlier.
Right. And maybe very different from what SPS's modeling in this case suggests might happen.
Absolutely.
And so if, I think you said this, but just to be kind of clear about it, if gas prices go down, that might mean that a unit like Tolk operates a little bit less. Is that correct?
All else held equal, yes.
Okay. And conversely, if gas prices went way up, as you, I think, testified, Tolk might operate more frequently.
Correct.
And if there's more wind online at a particular time, that might also cause Tolk to be dispatched less frequently. Is that correct?
That's correct.
And so to kind of tie a little bit of this together, I want to come back to the hearing examiner's analogy, because I think you agreed that it was a roughly acceptable analogy. If we're trying to use Tolk to get the 60 miles from Albuquerque to Santa Fe, and that's the goal. Let me back up, by the way. Tolk was built in about 1982 or 85, I believe the two units were built. Is that correct?
I think that's right. I'm checking here on the in-service date since I have this handy bench request. 1982 and 1985 with an original. Well, I'm sorry, I don't have the original retirement date. Apologies.
Yeah, no, but I just to kind of maybe put a finer point on the analogy that the hearing examiner came up with. Again, I think it was a pretty good one. It's almost as if Tolk is like SPS's 1985 Ford Bronco, and we're trying to see if we can get from Albuquerque to New Mexico. Now, the market monitor in this case, is it fair to say the market monitor will look at the cost to operate that Ford Bronco, the fuel, how much it might be penalized for environmental costs and the like, and we'll compare whether it makes sense to drive that car all the way to Santa Fe. Is that kind of a rough analogy?
Kind of.
Okay.
The reason I vary a little is because we're talking largely energy in the real-time market. SPP also evaluates the capacity position of load-serving entities, and that 1982 and 85 Bronco is 1,000 megawatts of capacity on SPS's system.
Okay, but fair enough. In terms of energy, and we'll use energy as a proxy for getting the distance to Santa Fe, rather, the market might determine that it makes sense to drive the Ford Bronco 30 miles only, and then take a gas-fired bus the remainder of the 30 miles. Is that possible?
Yes, and that is a basic provision of the SPP dispatch, is to ensure that the dispatch is most economical. And they do that across the footprint. And really, that's the primary focus of the market monitor also, is making sure that not only is the dispatch economical, but the offer prices are fair as well, right? Because the offer price is going to influence the economic dispatch.
Right. And so taken together, SPP's protocols, along with SPS's commitment here to limit its so-called self-commitment, its practice of binding itself to operate, those things together will ensure, or theoretically ensure, the least cost trip from Albuquerque to Santa Fe. Is that okay? And so it could be that the Tolk units are operated less than 4,000 gigawatt hours annually.
Correct.
And that would be to the benefit of customers if that's how it ended up being.
Correct. And I think what you've illustrated in your questions and what I was talking about with Ms. Lynch was the difference between modeling and real-time operations. So from a modeling perspective, we do have some granularity in the modeling, but generally we're focused on that production target. But in real-time operations, there are a multitude of factors that could reduce or change the dispatch of Tolk and influence that gigawatt hour production target on an annual basis.
Great. Thanks, Ms. Trammell. That's all I had. Thank you, Hearing Examiner Hurst, for indulging me.
Thank you, sir. Ms. Trammell, I believe that's all we have for you, and you are excused. Thank you.
Thank you, Your Honor.
Madam Examiner.
Ms. Hardy.
Thank you. I wanted to let you know that on the verifications to the bench responses, we have inadvertently omitted them. So we need, and I apologize for that. So we need to either get those verifications filed, we can do that tonight, or we could have the witnesses verify the accuracy of the responses on the record, which I believe Ms. Trammell did earlier when she was called, whatever Your Honor would prefer.
Well, as long as people don't have a problem with having the witnesses verify the information, no one's going to object to utilizing that. I mean, I think it's a helpful exhibit. That's why I'm, suggesting that we admit it as Commission Exhibit 5. But seriously, if people don't have any objection, you don't need to do more paper. Although you might have to change your verification, Miss Hardy, on those hourly rates.
Huh.
Yeah, see, Miss Trammell's still there. She heard that.
Yeah.
I see her. She's kind of chuckling too. No, I think we can do that. Like say, no one's objecting to that, and I think people are fine with that. So we can take care of it that way. Miss Trammell, you're going to have to exit the Zoom.
Yes, Your Honor. I just wanted to make sure if I understand correctly, do I need to verify the accuracy of the questions that you addressed with me or the questions I sponsor in your bench request?
I thought I asked you if they were true and correct, but let me go ahead in case I didn't. Are the answers that you gave me to the bench request true and correct?
Yes, Your Honor, they are.
Okay. Have any of your answers changed since Friday when they were filed?
No, ma'am.
Okay. All right. Thank you.
Thank you.
I appreciate it. You're excused. And I think we can call our how are we doing, Mr. Lee? Do we need a short break?
If you wouldn't mind.
All right, let's take a recess. It's let's take a 7-minute recess. We'll come back at 4 o'clock and we'll hear from Ms. Martin. I'll go ahead and admit her.
SPS Attorney 2, can you tell me who you are?
Jeffrey Stewart for SPS.
Is that STEWART?
STUART.
Thank you.
Yes, sir.
Mr. Stewart, are you with XL Energy or are you with Hinkle Shanner?
I'm with the law firm of Evershed Sutherland.
Thank you. Can you tell me your email address, Mr. Stewart?
Sure. Jeffrey Stewart, JEFFREY STUART at Eversheds-Sutherland SUTHERLAND.com.
Are you out of the Denver office?
I'm in Austin.
Thank you.
Mr. Lee, everybody assembled. Madam Hearing Examiner got kicked off. She's going to log back in here momentarily.
Thank you, sir. Mr. Stewart, is Mr. Moss with your office?
He is not. He's with the law firm of Winstead.
Winstead?
Yeah. WINSTEAD.
Do you know what office?
His office is in Austin, Texas as well.
Thank you.
Hello there. Sorry for the delay. You thought you lost me, didn't you? Apologize again for the IT problem. Hopefully, I'm going to be able to find out how we can do better tomorrow. So with that, let's go ahead and Ms. Hardy, you have a witness.
We do, Madam Examiner. Our next witness is Patricia L. Martin, and Mr. Stewart will present her testimony. I did want to mention that if we get through Ms. Martin's testimony, we would, well, I wanted to let you know that Mr. Diascendis is not available this afternoon. I don't know if we'll get through Ms. Martin, but I wanted to let you know that.
I appreciate that. And just as I indicated earlier, in trying to plan for tomorrow, I know that at least one of the commissioners has questions for Mr. Diascendis. So we are going to have to schedule his testimony after the open meeting. Okay. So we would have to move on. We'd have to skip Mr. Diascendis in the morning and either go on to the next SPS witness. So we'll have to think about that, but let's go ahead with Ms. Martin, who I have some questions for. And with that, Mr. Stewart, you have a witness.
Yes, Madam Hearing Examiner, SPS calls Miss Patricia L. Martin.
Good afternoon, Ms. Martin.
Afternoon.
Mr. Lee, would you please swear the witness?
Ms. Martin, would you please raise your right hand? You solemnly swear the testimony you're about to give in the matter not pending should be the truth, the whole truth, nothing but the truth?
I do.
Thank you, ma'am.
Go ahead, sir.
Good afternoon, Miss Martin. Could you please state your name for the record?
Patricia Martin.
And by whom are you employed and in what capacity?
I am employed by Excel Energy Services Company as the Assistant Treasurer.
And do you have in front of you what has been marked as SPS Exhibit 11?
I do.
And could you identify that document for me?
Sure. It is my direct testimony in this case, which we filed on November 18th of 2022.
And are there any attachments to that testimony?
Yes, there are.
Were your testimony and the attachments thereto prepared by you or under your direct supervision?
Yes.
And are they true and correct to the best of your knowledge?
Yes.
Ms. Martin, do you also, or excuse me, Madam Hearing Examiner, I would move to admit SPS Exhibit 11.
Any objection to what's been identified as SPS Exhibit 11? Ms. Martin's direct testimony as affirmed by her here today. Hearing no objection, SPS Exhibit 11 is admitted. Go ahead, sir.
Ms. Martin, do you also have in front of you what has been marked as SPS Exhibit 12?
I do.
Could you identify that document for me?
Yes, it's my rebuttal testimony in this case, filed on May 10th, 2023.
And are there any attachments to that rebuttal testimony?
Yes, there are.
And was your rebuttal testimony and the attachments thereto prepared by you or under your direct supervision?
Yes, they were.
And are they true and correct to the best of your knowledge?
Yes.
Madam Hearing Examiner, I would move to admit what has been marked as SPS Exhibit 12.
Any objection to what's been identified as SPS Exhibit 12, Ms. Martin's rebuttal testimony as verified by her here today? Hearing no objection, SPS Exhibit 12 is admitted. Sir?
Ms. Martin, do you also have in front of you what has been marked as SPS Exhibit 13?
I do.
And could you identify that document for me?
Yes, it's my testimony in support of the contested comprehensive stipulation.
And did you have any attachments to that testimony?
I did not.
And was that testimony prepared by you or under your direct supervision?
Yes, it was.
And is it true and correct to the best of your knowledge?
Yes.
Madam Hearing Examiner, I would move to admit what has been marked as SPS Exhibit 13.
Ms. Martin, how did you get out of filing supplemental testimony?
I'm not sure. I got lucky, I guess. Maybe they thought I had too many pages already.
Oh, they're giving you a page limit. Okay. Any objection to what's been identified as SPS Exhibit 13, Ms. Martin's testimony in support of the stipulation as verified by her here today? Hearing no objections, SPS Exhibit 13 is admitted. Mr. Stewart?
I would tender the witness for questioning.
Very well. And my recollection of the pre-hearing memorandum indicates that no one had any cross-examination for Ms. Martin. Due to the lateness of the hour, and other activities for tomorrow, Commissioner Ellison, I believe, sir, that you had questions for Ms. Martin?
Yes, I do.
Go ahead, sir.
Hi, Ms. Martin. Good afternoon.
Hello.
Thanks for appearing before us today. As I read your testimony, I guess the main gist of what I got was that SPS believes that retaining an investment grade rating from the rating agencies is important, and that if the New Mexico Commission doesn't give you what you're asking for, that this may cause you to lose it. Is that a fair characterization of your testimony?
I would maybe say it a little bit differently. We do support the stipulation in terms of its credit supportiveness to our current credit rating. If the commission were to reject all or parts of the stipulation, that could cause the rating agencies to take action based on their view of the credit supportiveness or the impact to our business risk.
Is the 54.7 equity ratio that you've requested required in order for you to hit the cash flow targets that the rating agencies are looking for?
I would say it would be a very supportive signal to keep our existing equity ratio of 54.7. We've been managing to that ratio for quite some time now. I think a headline of the commission ordering a lower equity ratio would be seen as non-credit supportive.
Professor Woolridge, in his testimony, I believe, has asserted an average of, I think it's about 50.5% equity over the last 3 years for SPS. Is that incorrect?
That is incorrect. He's just mixing up the regulated equity ratio that the company manages to versus the economic equity ratio that rating agencies use in their analysis. The difference is the additional off-balance sheet debt that the rating agencies impute for things like leases, purchase power agreements, things that the rating agencies see as long-term commitments that they treat as additional debt. They also consider short-term debt balances in making that calculation.
So the 50.5 that Mr. Woolridge is asserting is including the off balance sheet items, and the 54.7 that you're talking about is not including those items.
Correct. The key difference really is, from a regulatory standpoint, we want to make sure that whatever additional debt the rating agencies may impute, the economic ratio that they calculate is always lower than what the regulatory ratio is. There's about 450 basis points of additional debt that the rating agencies impute based on their adjustments that they made in 2022. So the 54.7 is without those adjustments.
And what is SPS's current allowed percentage of equity for New Mexico?
54.72, I believe.
Okay, I just recall in case 17-00255 that a 53.97 percent equity was allowed, and subsequently that was increased.
If I remember correctly, in the last case that was agreed upon in 2020, we used a 54.7% equity ratio in relation to the reconciliation for the wind farms, which is what we've been managing to.
Okay. Let's see. I wanted to bring up something from Professor Woolridge's testimony, a chart on page 116. I'm not sure if I'm allowed to share my screen, Madam Hearing Examiner, or if
Yes,
that's
sir.
something that you might be able to bring up for us.
Well, why don't, just because I don't know where that button is,
Well, I think, you know,
let me
who
pull
has
it up for you.
Okay.
I can surely do that. And
It's exhibit JRW3, page 116 of the PDF.
okay,
I can just talk through it as well if that's
no, I've
different.
I've got it. Okay. Is that it?
No, I think it might be the next page. Yes, the table on the next page, and specifically that part B, that table, the Deascendis proxy group. So Ms. Martin, these utilities on the proxy group, these are all regulated utilities. Is that correct?
To the best of my knowledge, correct.
Okay. And if you look at the common equity ratio for these companies, I'm seeing a mean of 41.7% equity. And it looks like the only company that would be higher than SPS is IDACorp with a 56% common equity ratio. And all of these companies have investment grade ratings. Is that correct?
That's correct.
Okay. So, I'm just wondering, why it is that, these companies can maintain an investment grade rating with an average equity of 42%, yet you're telling us that unless we authorize almost 55% for SPS, that it'll be in jeopardy of a downgrade.
Sure. If I could point out, Excel Energy Inc. as referenced on this chart is our parent holding company. So that would be the consolidated equity ratio for our entire group of companies. Off the top of my head, I believe the same situation would be for Duke Energy and American Electric Power. So they're not directly comparable to SPS as the regulated utility company. I'll offer you a couple pieces of data here. First of all, SPS is its own separate regulated operating company. It issues its own debt. It has its own financial statements and its own credit rating. The credit ratings and metrics of SPS are primarily done on a standalone basis, meaning Moody's and Fitch really only look at SPS as its own entity and ignore the influence of the parent company or any of the sister companies to SPS. The equity ratio that we asked for in this case is needed to support the metrics and is based on not just that piece of data in isolation, it's based on the overall regulatory complex, meaning other companies might have different regulatory agreements or mechanisms in place. They might have different circumstances than we do. So while it does give you a data point to look at proxy groups, the correct comparison is the specific facts and circumstances that are facing SPS. I will also offer another data point that in 2018, SPS was downgraded by Moody's because of a proposed recommendation by the commission at that time to give up the 51% equity ratio. That was both based on weakening credit metrics as well as their view of a less supportive regulatory environment. So since that decision, we have needed to manage to a higher equity ratio to maintain our current ratings and metrics.
And to be clear, SPS has regulators in Texas and in New Mexico. So what happens in New Mexico is not the sole determinant of what the rating agencies decide. Is that correct?
That's correct. They're looking at decisions made in both jurisdictions.
Okay. And that deteriorating cash flow metric, I think it's cash flow from operations divided by debt? Is that what Moody's looks at?
That's their main credit metric. S&P as well has a similar primary credit metric, which is called FFO, or funds from operations to debt.
And what's the primary reason that deteriorated?
The reasons that Moody's cited in the report, which they downgraded us, it was at the time TCJA, the Tax Cuts and Jobs Act, had the effect of weakening our credit metrics, along with the elevated capital expenditure profile from some of the work that we were doing.
Right, I see. So, that's not necessarily a function of what the New Mexico Commission decided. It sounds like there were other factors involved.
There were, they cited both weakening credit metrics as well as their concern about weakening regulatory supportiveness. Specifically in New Mexico, but they do mention, this is in one of my attachments to my direct testimony at attachment PLM 8. They're also citing a less predictable regulatory environment in both Texas and New Mexico.
Okay. In your view, are ratings the only factor that the New Mexico Commission needs to take into account when setting rates?
I think ratings are really, really important because investors use credit ratings as a signal of the risk of any company. And we are competing for capital with not only other utilities, but other companies and other industries. A credit rating acts exactly like your personal FICO score. So the higher it is, the more people that are interested in purchasing your debt and at a lower cost. So the credit rating is very important to us in terms of being able to meet all of the renewable energy goals, continue to provide safe and reliable power at an affordable cost to the customer. Since the cost of capital is a direct pass-through, it's very important for us to maintain our strong financial integrity so that we can access capital markets in any market condition at a reasonable cost of capital. I'll also give you one example in practice of why it's so important to have strong financial integrity. Winter Storm Uri that occurred in 2021, I believe across the SPS complex, we incurred, I can't remember the exact dollar amount of cost, but I think it was $100 million or thereabouts. $22 million of that was in New Mexico. We offered to extend the recovery of those costs over a period of time with no financing carrying cost. We wouldn't be able to do things like that when we're facing kind of unexpected economic environments. If we didn't have strong financial integrity and weren't able to access capital and have strong credit ratings.
So it would be fair to say that, our charge is setting reasonable and just rates, and to the extent that having a credit rating could, a good credit rating could help lower rates, it's a factor to keep in mind. But setting reasonable and just rates is really our primary concern. Wouldn't you agree?
Agree. We believe that the terms set in this stipulation offer a balance between maintaining the company's current financial integrity and affordability to the customer.
Have you provided information as to the percent equity in the other Excel subsidiaries?
I'm not sure. That may have been a discovery question, but I don't believe that I provided that in my direct or rebuttal testimony.
How does what you're requesting compare to what the other Excel subsidiaries have as allowed equity?
Keep in mind that every company has different regulatory constructs and recovery mechanisms. Public Service of Colorado has a 55.69 electric approved equity ratio at the current time. NSP Minnesota and NSP Wisconsin are both at 5250. Both of those companies utilize multi-year plans, forward test years, and a variety of rider recovery mechanisms. Other differences off the top of my head, and I don't know all the specifics right at the moment, but depreciation lives between companies could be different. So it really is very dependent on the facts and circumstances of each company.
What's the minimum percentage equity that from the New Mexico jurisdiction that SPS would need in order to hit the cash flow metrics that you're trying to achieve?
I think the 54.7% that we've presented as part of the stipulation is what we need to maintain our current cash flow metrics.
I see, but previously, we know that you've had a lower number such as the 53.97, and you obviously were able to maintain an investment grade rating with that.
Our goal is not to just maintain an investment grade rating. I think it's very dangerous if you're hanging out at the very bottom of the number target for a downgrade by a credit rating agency, because we don't have the flexibility or the financial integrity to weather different economic events. Like I mentioned, Winter Storm Uri. Earlier this year, we saw some severe market disruptions due to the Silicon Valley Bank failure and the resulting, there was a few other banks that made some headlines. If you're sitting at the very bottom of your target to maintain your current level of investment grade rating, you really don't have the flexibility to maybe weather some of those stressful events in the market.
Based on that logic, however, you could say that you really need a very high equity percentage and a very high ROE, the higher the better, so that you could show the rating agencies that you have strong metrics. Is that true?
You could say that. I would say, though, that what we're asking for or what we're supporting in this stipulation does not do anything to improve our current level of financial integrity or credit rating. It just maintains where we're at. Which I would like to point out that SPS is already rated below average credit quality. Moody's and Fitch both have them rated as a BAA. Moody's had BAA2 and Fitch has BBB flat, we call it. There's no plus or minus. That's only one level above non-investment grade rating. So access to capital becomes more expensive and less available when you're starting to hang out at either just barely investment grade or below investment grade. So we desire to make sure that we don't get close to that downgrade level.
So does management have anything to do with it? Could skillful and efficient management improve the cash flow and other metrics, or are you totally dependent on what the regulators decide?
I think it's a mix of both. So of course, good management of O&M expenses, being very disciplined about our capital plan, all of those things, of course, contribute to strong credit metrics. But I will point out that our primary source of revenue for SPS is through the regulated rate making process. As a matter of practice, we do manage our equity ratio to the authorized equity ratio by our commissions. So if in this case, as an example, a lower equity ratio was authorized, we would take that as a signal of what the commission wanted us to do, and we would manage to that lower level.
Right, I see. And in your forecasts that you've got, such as table 8 in your testimony on page 43,
testimony?
These table 8 on page 43 of your direct testimony.
Yep.
The CFO pre-working capital divided by the debt. So these numbers, well, I guess the new rates would only take place essentially in 2024, correct? So the 2022 and the 2023 forecasts are using current rates that are in place. Is that right?
The 2023 would have current rates for sure. So yes, I believe that 2024, these credit metrics though reflect the original ask in this case and not the stipulation in this case. I just wanted to make sure that was clear.
I understand, but that would, again, that would only impact the forecast 2024, correct? Because the rates would come into effect obviously too late to affect 2022 and pretty late in 2023, if at all. Is that correct?
Correct.
Okay. So it looks like your ratio has been improving with the existing rate structure. Is that a fair assessment?
According to the metrics, yes.
Okay.
I do believe that part of that, if I may, and again, I'm not the expert here. I'd almost defer on some of the specifics to witness Ms. Mimi. But I believe we had rider recovery in place for our wind farms that recently changed over to base rates.
And if the you discuss the production tax credit for the two wind farms in your testimony, if that can be sold, then that could substantially improve these cash flow metrics. Is that correct?
Theoretically, yes. The market has not yet developed and is still evolving. And the rating agencies have not given guidance as of this point on how they will treat the sales of tax credits from a metric standpoint. So we're waiting to hear some guidance on that.
Okay. But you know, again, thinking back to that chart of the Ascendus proxy group with all pretty low equity numbers compared to SPS, they are able to maintain a investment grade rating. So wouldn't it stand to reason that SPS could also maintain an investment grade rating with a New Mexico authorized equity of something less than 54.7%?
I don't think you can only use a proxy group average as a comparison. I'm not familiar with the specific facts and circumstances of all of their regulatory constructs in terms of whether they get rider recovery on some of their projects, their level of capital spending, their ROE versus their equity ratio. things of that nature, they could have very different circumstances from SPS. I'll also offer to you that in terms of the credit rating methodology, they look at both financial risk as well as business risk. So while the equity ratio in isolation is part of the financial calculation, rating agencies also look at that as a signal of business risk. So if we were to get a decision that lowered cash flow and lowered our credit metrics, that puts more financial risk on the company. It also raises our level of business risk because they would see that as a non-supportive decision, given that we have reached a stipulation in this case with the 54/7 equity ratio. So, you know, trying to get down to a lower cost of capital purely based on the numbers can sometimes have the opposite effect of that, because it raises perceived risk, and then investors would actually demand a higher cost of capital. If I may, I have a real life example of this. The difference in ratings between NSPM as an example, NSPM has an A- rating, SPS has a BBB rating. So 2 notches lower. In 2022, we actually priced a Minnesota and an SPS bond very close to each other in the same market conditions. SPS, primarily because of their lower credit rating, paid a higher spread. So bonds are priced based on the underlying treasury rate plus a spread. SPS paid up 65 basis points over Minnesota because of the lower, primarily because of the lower credit rating. So this perceived level of risk really does translate into real cost to the customer in terms of the cost of capital.
Do the rating agencies care about the public interest? Do they care about reasonable and just rates, or do they just care about increasing cash flow metrics?
I think the answer is both. They do make commentary about customer affordability. They do make commentary about the level of capital expenditures and what is manageable. But at the end of the day, they're giving a signal of our ability to meet our financial obligations. So to repay debt and to give investors a fair return, which influences our access to the capital markets. And in order for us to meet some of our renewable energy goals and to continue to provide safe and reliable energy, we do need to continue to have access to the capital markets.
Sure, of course. Would you be willing to do a calculation to forecast that key cash flow metric under the assumption of, say, 51 or 52% equity?
Yes, we can absolutely give you the numbers, but I would just like to remind you again that it's not just the metric itself, it's also the perception of the increased business risk that influences credit ratings.
Sure, I understand.
And I'm sorry, you said 51% and 54%?
52, 51 and 52. So,
Mr. Stewart, do you understand the bench request from the commissioner?
Yes, Madam Hearing Examiner.
All right, go ahead, Commissioner.
and I think that's all the questions I have. Thank you, Ms. Martin. I appreciate it.
Thank you. It's nice talking with you.
Thank you.
Do any of the other commissioners have questions for Ms. Martin? Hearing,
Thank you.
Mr. Chair, did you say no?
Yes, I said no.
Okay, thank you. Commissioner Aguilar, any questions?
I don't have any questions either, Madam Hearing Examiner. Thank you.
All right, Thank you. Again, I don't believe anybody scheduled any time for cross. I've got a few questions for you, Ms. Martin. And I guess first I'd like some type of explanation on sort of the differences in the job assignments or the actual titles of the various witnesses. It seems as if we have you who is the Excel assistant treasurer, correct?
Correct.
But we also have Ms. Nemi, who's the Excel manager of revenue analysis, correct?
Correct.
And then we have Ms. Koch, who is primary function is tax reporting.
Correct.
And then we have Mr. Davis, who's the director of accounting.
Correct.
And I'm sure I've probably forgotten some other SPS witnesses that provide number calculations and analysis. Why do we have all these different people?
I can't speak to everyone's testimony specifically in what they speak to, but we all have very different roles and manage very different things. My role as assistant treasurer, I'm responsible for the day-to-day financing of the company, including capital markets execution, managing the capital structures of each of our 5 companies, the parent company and each of the 4 regulated utilities, banking relationships, maintaining our financial integrity, in short. Ms. Nemi is responsible for the very detailed revenue requirements modeling, and goes into a lot more detail than I do in terms of all of the inputs that she covers in her model. Naomi Koch, Ms. Koch, talks about very detailed tax issues. So in terms of policy around IRA, for example, their team does a lot of the heavy duty modeling and how that impacts our tax burden going forward. I really just get into financing the company, and I'm sorry, I don't know what Mr. Davis is speaking to in his testimony. I just really get into financial integrity issues, capital structure, rating agency considerations based on what the rating agencies are publishing and management of our day-to-day financing. Very different roles internally.
Have you ever done return on equity?
As a witness or as part of?
Yes.
No, I have not.
Are you aware that that used to be an internal function?
I was not.
On page 8 of your direct testimony, you're answering the question posed on page 7. Please explain any differences between the base period, linkage period, and future test year capital structures and the WAC. Capital W, capital A, capital C, capital C. And then so you're continuing your answer on page 8 and at lines 6 through 11, you say the differences in WAC are primarily driven by the difference between the base period ROE of 9.45 and SPS's proposed ROE of 10.75. Is that correct?
That's correct.
And the base period ROE was an actual 9.45.
I believe that was the authorized ROE.
Authorized in which case?
I'd have to check on that, to be honest with you. That should be the what was authorized in the case that was completed in 2020. I'm sorry, I don't have the reference off the top of my head.
Well, subject to check, would you accept that it came from the certificate or the stipulation in case number 19-00170?
Subject to check, yes.
Where, and I was wrong, it wasn't an internal witness. I think your witness was, her name was Ann Bulkley, Bulkley. And she testified as recited on page 37 of the certification of stipulation. With respect to ROE, SPS witness Bulkley, and I believe she was with the consulting group Concentric, testified that the 9.45 ROE established by the stipulation is within a range of reasonable results in the context of a comprehensive settlement. According to Ms. Bulkley, the stipulation has been received by Moody's as credit positive. Are you familiar with that?
I'm not.
And that is a reference. That's a footnote 78, and it references Ms. Bulkley's February 18th, 20 testimony, transcript, page 85, lines 9 through 25. So it would seem that at least in case number 19-170, which the 19 indicates it was filed in 2019, and presumably the decision in 2020 the rating agencies, at least at that point, might have indicated a favorable regulatory climate with respect to that particular decision, don't you think?
I will agree with you that in recent Moody's reports in particular, and I'm speaking to Moody's because they are the agency that downgraded SPS in 2018, They have noted that more recent decisions have been credit supportive. I will also point out that they have not gone so far as to upgrade us to our former triple B plus credit rating.
Well, and I want to talk to you about that, but I want to try to find out, okay, so you utilize this presumably 9.45 because I'm pretty sure that case number 20-00238 had a very limited application of a 9.38 ROE. Would you agree with that?
I don't recall the specific details, but I do recall that it was a limited application related to the reconciliation of the wind farms.
Well, I mean, obviously, this is your testimony, Ms. Martin. So again, when you say base period ROE, you know, I want to know specifically why you use that ROE and where it came from.
That is also the ROE or close to the ROE that we've been managing to for quite some time internally.
So could I presume then it's an actual ROE for the base period?
No, I would have to check on the actual ROE calculation for 2021. I believe it was significantly lower than that. The earned ROE, I think you mean.
I do. Consider that a bench request 5. I want to know what the earned ROE was for the base period. And as far as bench request 6, I want to know where you got that 9.45. What if you came from a case that's as close as I could try to figure it out, was to go to case 19-170. Most times when SPS wants to cite to an ROE, they go to the last litigated case, or at least that's where they try to utilize the WAC from. And I believe that your last litigated rate case was 17-00255, and that actually got a ROE that was a settled. It was a settled ROE from the appeals cases.
We'll provide clarification around that.
Okay. And just so that when we're looking at these capital structures, just so the record's clear, it's not just the higher ROE that provides for increased profits to the shareholders, but also the higher common equity. The higher the common equity is, it's going to provide more increases to shareholders, correct?
That's correct.
Because equity is more expensive than debt, right?
In general, that's correct. I would say from a credit metrics management standpoint, the equity ratio is very efficient in terms of the revenue requirement, because maintaining a higher equity ratio both displaces interest expense in the CFO numerator of the equation, and it displaces debt in the denominator. So in terms of the impact to the revenue requirement, in terms of maintaining our credit metrics, the equity ratio is a very efficient lever in maintaining financial integrity while minimizing the impact to the revenue requirement.
So in looking at your testimony, beginning on page 10, and I'm looking at page 12, you're testifying on SPS's perspective on financial, and not just SPS's, but since you're the assistant treasurer for Excel, this is Excel's position on financial integrity, isn't it?
If you're referring to my testimony on page 12, I'm directly quoting from the Moody's article where they downgraded us in 2018.
Right, but I'm saying, you know, when your testimony, the basis of your testimony about how to maintain financial integrity is not just perspective for SPS, but it's perspective for, since you work for Excel, I'm assuming it's Excel's perspective on maintaining financial integrity, right?
Yeah, we're working to maintain the financial integrity of each of our 5 companies. Yes.
Okay.
You raise
So-
debt separately at each company. So it's very important to maintain our credit ratings at each company.
Okay. And in testifying on page 12 about the investor perceptions of the regulatory environment, you cite to the fourth quarter 2018 Moody's downgrade of SPS, correct?
Correct.
And at that particular time, Fitch and S&P did not downgrade SPS, did they?
They did not. S&P takes the approach of using a family style rating. So they consider the influence of the parent and the rest of the members of the family, they call it. They do assign a standalone credit profile that only takes into consideration the specific financial metrics and circumstances of SPS. I will point out that Fitch and the standalone credit profile at S&P, while they were not downgraded, they are also at the same level as the Moody's rating, the downgraded rating from 2018 at BBB flat.
So the answer to my question was no.
Correct.
What I don't seem to understand is since that time period in 2018, SPS has had, well, it's had 2 completed rate cases and it's on its 3rd one with the instant case. So you had a rate case, and the one I referenced, 19-00170, that you entered into a STIP, you got a revenue increase of $31 million, $8 million more in depreciation rates, and various other items. You had a ROE of 9.45, a 54.77 common equity, resulting in a WACC of 7.19. It was an overall 11.37% base revenue increase. And you got $1.2 million in rate case expenses. Additionally, last year, on the 16th of February, in case number 20-00238, SPS had another stipulation approved by the commission. where they got $62,423,334 increase in non-fuel base rate revenues. You got a 9.35 ROE, a 7.07 WACC, a 54.72 common equity. Again, the stipulation says for purposes of Hale and Sagamore and for reconciliation purposes. If I look at that, and I don't have accountants or treasurers or revenue analysts, but if I just put down a few numbers and I have 7 months in 2020, 12 months in 2021, 1 month in 22 before you file, in a 20-month period, SPS negotiated its way to a $93.5 million revenue increase. Now, wouldn't you think that one of these credit rating agencies, if they really cared about what was going on, would have upgraded SPS for its fine work and getting almost $100 million?
They have not. In fact, neither of the three agencies have changed the rating in the last several years. Their methodology quotes, they want to see a pattern of stable, predictable, transparent regulation and sustained improvement in credit metrics. So once you get downgraded, it's very difficult and it takes a period of time to regain your former rating. This is not
How
something
long?
that happens quickly. They downgraded us 5 years ago and we haven't seen it yet. So I don't know the answer to that. I think it's different based on every company's circumstances.
Well, I mean, you say on page 13, at lines 10 and 11, the rating agencies have also emphasized the importance of moving toward balanced constructive outcomes in utility rate proceedings. Well, I don't know how more balanced and constructive than getting a $93 million revenue increase that you stipulated to. I mean, what do they want? Do they want the commission to be standing on 1 foot? Smiling at SPS when they make these decisions?
I do think the approval of the stipulation in this case would also be seen as yet another step towards a very productive regulatory environment. I also think that they're looking for us to make sure that we're maintaining those credit metrics in a range where they are currently, and not seeing any degradation in credit metrics.
Well, you say on page 14, they've not taken action to upgrade the credit ratings of SPS. You say this demonstrates this rating agencies need to see a pattern of consistent, predictable regulatory outcomes before taking an upward action on rating. Well, I gotta say, if you keep relying on them as a reason, as a foundation for why you should get a certain credit metric, and nothing's been done over 5 years, it just causes me some to question how important this rating is if the commission basically the one case that was pointed to was the 17,255, and SPS didn't get what it asked for, and the commission changed in the final order change the ROE, but in the stipulation or in the stipulated agreement to resolve the 3 appeals, they came back and they gave SPS a 9.56, I think, which was higher than had been recommended by the hearing examiner or the commission. So I don't know what kind of expectations SPS has of the commission, Ms. Martin.
I can't speak to what the rating agencies are looking for. We believe that in this stipulation, approval of the stipulation would be yet another sign to the rating agencies and investors that this is a supportive regulatory environment. And that is important to us because it's such a big part of the overall credit assessment and the risk assessment of SPS, which does have an impact on the overall cost of capital. SPS is paying an elevated cost of capital over our higher rated sister companies. So it does have an impact to customers.
You say on page 15 of your testimony at lines 5, to maintain a strong financial profile, a utility needs to have the opportunity to recover all prudently incurred utility costs in a timely manner, which includes not only the cost of capital investments and operations and maintenance, but also the cost of servicing debt and providing a fair return on equity. Well, if you get what you want in by stipulation and final order of the commission and in the past 3, 4, 5 rate cases, I don't know what else that the rating agency would expect from a regulatory environment. Are we supposed to give you more than you ask for?
I can't speak for them. I think they're just looking to see a continued pattern of supportiveness and maintaining those financial metrics.
Well, I think you speak a lot, Ms. Martin, about what you think that the rating agencies want. I think that's what your testimony is all about.
Well, that's also based on informed knowledge from the methodologies they publish about what factors go into their ratings, as well as what they're writing about us on an annual basis.
Well, do you happen to think that perhaps it's not necessarily just the regulatory environment? I mean, in a question that the commissioner asked you about the behavior of and management of the company, you know, by its directors. You know, I mean, looking at your testimony on page 20 on how regulatory risk is analyzed, you know, you say, beginning on line 2, regulatory risk constitutes 60% of the credit profile. And for S&P, it's 80%. And then you have the different things. And that reading that led me to believe that, or question, do you believe that they consider how the utility operates in the regulatory environment? So, for example, how often they file for certain kinds of cases, how often they appeal. Do they appeal every case that they don't like the result? And does it make any difference, for example, if they do file these appeals, does a rating agency actually look at whether they win or whether they lose the appeal?
I think the rating agencies are looking at everything, quite honestly. And, you know, their methodology quotes these numbers that I'm giving, the 60% and 80%, but they are also looking at what management does. Again, efficiently managing our expenses shows up in the form of financial metrics. They're looking at, you know, how we're executing on our capital plans and the work that we're saying that we're going to do. They're making sure we're doing that efficiently. they're looking at any negative events that happen as a result of our management as well. But the fact of the matter is, since our revenue is almost entirely generated, and in SPS's case, it is entirely generated out of the regulated rate making process, that does play an oversized role in their assessment of the risk of our company.
Well, let's move on and look at page 24 of your testimony. How does regulatory lag impact a regulated utilities credit metrics? Which you answer at beginning in line 14, regulatory lag reduces cash flow and increases debt levels, both of which have a negative impact on credit metrics. So you're saying that's considered by the credit rating agencies, correct?
Correct. As part of their rating methodology, that's correct.
Well, when they're considering these, what they're referring to as regulatory lag, do you believe that they actually look in, that they're just looking at a point A to point B time frame? Or do you think that they actually consider the behavior of the utility in contributing to how long it takes to get a case processed, perhaps because of inadequate filings, or for things like in this case, the instant case we're hearing now, SPS's request to extend the suspension period for purposes of negotiation? Do they consider those kind of things when they're trying to ding somebody for regulatory lag?
I can't speak to specifically all of the factors that they consider in terms of regulatory lag.
Your testimony at page 44, question posed at line 11, do all tax credits qualify for transferability? And you're referring to the production tax credits that are being generated by the Hale and Sagamore wind facilities. Is that correct?
Correct.
Are you generally familiar with the stipulation in 17-00044? And that was the CCN case?
I'm not. I'm sorry, no.
Okay. I thought maybe we could get an explanation for how those credits occurred, but I'll move on. Page 45 of your testimony, the question posed at line 15, what would be the implication to SPS's credit rating under the IRA scenario? And that is referring to the Inflation Reduction Act of August 22, correct?
Correct.
And so you say that line 17 and carrying on to the next page, SPS's credit rating could improve if, one, the commission approves a constructive base rate outcome, including approval of SPS's requested capital structure. Two, approves, I guess the commission approves a regulatory construct under which SPS could sell PTCs. Three, a market for tax credit transferability were to develop. You're not asking the commission to do anything on that, right?
No, that's correct.
Number 4, SPS were able to monetize PTCs. That's not the same as 2.
Yes. It's the same as if 1 and 2 are approved or happen. And as a result of that, we could monetize PTCs. So yes, that is somewhat repetitive to numbers 1 and 2.
Do you really think there's going to be a market?
We've had some, I don't know. It's all remains to be seen. It's very theoretical at this point. There has been some general interest by companies outside of the industry, but there hasn't been, especially related to Excel Energy and its subsidiaries, there have not been any transactions at this time.
Well, I mean, are you familiar with the market for RECs?
I'm not, no.
Capital R, capital E, capital C, renewable energy certificates.
Mhm. I know that there is a market for that. I'm not at all familiar with the mechanics.
Okay. What's your prediction or probability that you think all 5? Oh, number 5 was SPS does not face other negative regulatory or financial outcomes. What's the probability you think that all 5 of these things are going to happen, Ms. Martin?
I'll throw one other caveat in there. To this point, the rating agencies haven't given any guidance on whether they will actually consider the cash flow impact of tax credit transferability in our metrics. So that would be the wild card in addition to the things I've listed here. I would hate to even give a probability on that because I think that's a lot of things that need to come together. I think there is a likelihood it will happen. I just don't want to caveat what percentage that might be or when it might actually happen.
Thank you. I appreciate your time. Mr. Stewart, is there going to be any redirect?
Yes, I have some questions.
What kind of time frame do you have?
I can try it. If we can do it this evening, I hope we could get it done in 10 minutes. 15
Mr. Lee,
minutes.
can we go 10 minutes more?
Yes,
How you
ma'am.
doing?
Yes, ma'am.
All right. Let's try to get Ms. Martin done then. Or to be more specific, have her testimony complete. Go ahead, Mr. Stewart.
Thank you, Madam Hearing Examiner. And would it be possible to pull back up Mr. Ward's testimony in that page? I think it was 117 of the PDF that we discussed earlier.
Oh, Dr. Woolwich? Okay,
Yes.
I can do that.
And
See, you're lucky because you're deferring it to me, but under the Santa Fe latte rule, I'm doing it for free. Think that was it.
Nothing's on the screen, Judge.
thank you. And Ms. Martin, do you recall some questions regarding this panel B at the bottom of this exhibit?
I do.
And the companies that are listed in this table, are these actual electric utility companies?
If I'm going through it, I believe Alliant Energy, Ameren, AEP, Duke, most of these are utility holding companies as I go through the list.
And so like Xcel Energy, for example, is a holding company. It's not an electric utility itself.
That's correct.
And, another example would be, if you know, Entergy Corporation is a utility holding company.
Yes, that's correct.
And underneath those utility holding companies, are there separate operating companies?
Correct.
And do you have an opinion as to whether it is appropriate to set a capital structure at the utility holding company level?
I don't believe it's appropriate to set the capital structure based on the parent company holding structure. Speaking in general, holding companies can have a mix of regulated and non-regulated businesses. And speaking of our holding company in particular, we don't generate any revenue out of our holding company. We do have expense there. So it's not appropriate to compare our holding company to the regulated utility. The circumstances are not similar.
And do you have any information on the actual capital structures of the operating companies under these holding companies?
Ours in particular, or these other holding companies?
Xcel and the other operating companies.
I can speak generally to the capital structures of Xcel Energy's regulated companies, but I can't speak to any of the other operating companies underneath these holding companies.
Hearing examiner Hurst, would it be possible to pull up one other document, and it would be in the direct testimony of Dylan Descendis? Which is marked as SPS Exhibit 16.
What page, sir?
I'm looking at, I believe it should be PDF page 121. One more page down, I'm sorry.
Is that it?
Yes. Ms. Martin, are you familiar with this schedule that is up on the screen?
I've seen it generally, yes.
And do you know whether the companies listed here are actual operating companies?
They are, yes.
In other words, they are not holding companies?
Correct.
And can you identify for me what the highest common equity ratio is as shown for these companies here?
It looks like Duke Energy Ohio, as I'm going down the list, has a 58.26 common equity ratio.
And just generally looking at this, there are many other operating companies that are at 52 or above %. Is that fair?
That's fair.
And Ms. Martin, you were asked some questions about the capital structures for the other Xcel operating companies. Do you recall those questions?
Yes.
Can you explain what or compare the current credit ratings for those other operating companies as compared to SPS?
Yes. SPS has the lowest credit rating within our complex of companies. NSP Minnesota has a corporate rating of A-. NSPW has a corporate rating of A-. Public Service Company of Colorado has a corporate rating of A-. And Xcel Energy as the parent company has a corporate rating of A-. Those are all S&P ratings as they do rate family style. From a Moody's perspective, Excel is rated Baa1. NSPM is rated as A2. Wisconsin does not have a corporate rating by Moody's. PSCO is rated A3. And SPS is rated Baa2.
And so SPS is the lowest out of those operating companies and the holding company.
That is correct.
Ms. Martin, do you recall some questions about approximately $100 million base rate increase over the last two stipulations that was authorized by the New Mexico Commission?
Yes.
Do you have any sense of the level of capital investment that SPS has made in that general time frame?
Oh gosh, off the top of my head, I don't remember our annual CapEx over the last several years. I think just speaking to this year, I think our capital plan is somewhere in the neighborhood of I don't even want to fathom a guess. I know it's $3.9 billion over the next 5 years. I know that the major wind farms went in over the time period that we're talking about.
And what was the combined capital investment roughly for the major wind farms, Hale and Sagamore?
I'm not sure off the top of my head. I apologize.
Okay, and lastly, Ms. Martin, could you turn to page 50 of your direct testimony for me?
Yes, I'm there.
And I am looking at table PLM-9. Do you see that?
Yes.
And this is showing the WACC as of June 30th, 2022. Is that right?
That's correct.
And June 30th, 2022 is the end of the base period.
Correct.
And could you look at footnote 38 for me?
Yes, I'm there.
And that says reflects ROE authorized in case number 19-00170-UT, correct?
That's correct.
And when we go back and look at the table, that ROE is 9.45%.
That's correct.
No further questions.
So that's the answer, Mr. Stewart, to bench request 6.
Yes, Madam Hearing Examiner.
Thank you. Mark that one off. All right, any questions based on my questions, on the commissioner's questions? Hearing none. It appears then that we have concluded the testimony of Ms. Martin. Thank you, Ms. Martin. Appreciate your time. You are excused. Okay, before we end for the evening, just a couple of logistical items. As I previously indicated, the commission has an open meeting tomorrow morning. I do not know how long the open meeting might last, but in an effort to try to make sure that we get the witnesses available that the commission might have questions for, I'm going to suggest that Mr. D'Ascendas not be available until 11 o'clock. And that'll be subject to the commission's availability to ask him questions. Also, in looking at our constrained witnesses, it would appear that we also are going to need to call Ms. Crane and Ms. Glick in the next couple of days, and then hear from, I believe, Dr. Woolrich is only available on Friday. So with that being said, when we look at our order of witness appearances, We're going to, like I say, not have Mr. D'Ascendis until late morning or after lunch tomorrow. And so I believe that according to the witness list, then we're going to go ahead and potentially question Mr. Davis and possibly Mr. Cooley before that would occur.
Madam Examiner, I have one.
Ms. Hardy.
Thank you. One more witness issue I wanted to mention, and that is that Richard Belt would like to testify tomorrow if at all possible. He has a scheduling conflict the next day.
Okay. Well, at least based on the deferred questions today, there may be commission questions for Mr. Belt, because Mr. Belt is the chemistry and water witness, correct?
Correct. He's the water witness.
Okay. Commissioners, did you have any questions for Mr. Belt?
I don't.
I do not.
Okay.
I don't have any either.
Okay. All right. Well, in an effort then to get Mr. Belt to accommodate him, why don't we start with Mr. Belt then at 9 o'clock tomorrow morning?
That would be great. Thank you.
Okay. Very well.
Miss Hearing Examiner Hurst, I also have an update regarding Mr. Long's availability.
Okay.
I doubt that it'll cause any conflict, but he is not available tomorrow after 4 Mountain Time. So any testimony that he'd be presenting would need to conclude by 4. He
Okay.
is available the morning of the 22nd or beyond.
Okay. I didn't.
That constraint is new
Okay.
based upon some family obligations. I did
Okay.
not know.
All right. Okay. Very well. We'll start in the morning then with Mr. Belt and any questions, and then like I say, we'll go back to our list and then hear from Mr. D'Ascendis. And like I say, I will not forget about the AG witnesses availability, as well as looks like we have to get to Ms. Glick by Thursday. Okay, great. I appreciate your time, and we are going to recess until 9 o'clock tomorrow morning. Tune in about 10 minutes before, and hopefully, if you have any procedural issues, we can discuss those and then resume at 9 o'clock. So thank you all very much, and we are recessed.